Good afternoon, ladies and gentlemen. The Metropolitan Board of Zoning Appeals is now in session for its regularly scheduled meeting of December the 5th, 2024. I am Joey Hargis. I'm the Metro Zoning Administrator, and I'll be presenting the cases for view on today's agenda. Board would ask if you do have a cell phone to put your cell phone on silent or vibrate so as not to interrupt today's proceedings. We would certainly appreciate that. The process will be to go through the cases listed on public hearing today. The board will first deal with items on old business, and then new business comes after that. The board will hear testimony from both sides of a case if there's opposition. The process will be first, I'll go first and present the Codes Department's presentation on the wall here by means of a PowerPoint presentation. And I'll present any photographs and sketches and maps and pictures taken of the site. And then after my presentation, the applicant will come first to the table, along with any persons in support of a case. If you're here on a case that has opposition, you'll have 10 minutes to present your case to the board. And that includes testimony of persons in support. Just a word of advice, you may want to save some of your 10 minutes for rebuttal because after you speak, the opposition will come up. And then the opposition as a side has 10 minutes to present a case. Now again, that's 10 minutes as a group, not per speaker. So if you have multiple speakers for a case, be sure to divide your time accordingly before you come up. Once the opposition's had a chance to speak, the appellant will have a chance for rebuttal for whatever remaining time they have left from their initial 10 minutes. The board's vested to act on the powers today. In front of you is under section 1740-180 of the Metro Code of Law. The board requires that there be 4 members present to constitute a quorum. I do have 4 members present today. For cases on the agenda you will need 4 affirmative votes to grant your case today. So you will need all 4 of these members' votes in your favor to grant your case. If you fail to do so, your case will be on our agenda for the next 30 days. We'll have 1 meeting in that 30-day period. The other members who are not present can watch the proceedings that are recorded and review the packet and become eligible at the next meeting. We'll have one of those types of cases today. And then vote on the case. If after 30 days there are still not 4 affirmative votes, your case is deemed denied by operation of law. The board will go through all cases set for public hearing, and then we'll vote and discuss the cases in front of you. Should be noted that it's found if anyone's presenting false or misleading testimony to this board that may have affected this board's decision, any approval can be revoked at a later date by means of a show cause hearing. Again, I've got a few preliminary announcements, members. I've got a couple cases that have been postponed until a later date. The first of which is case under new business at the bottom of page 2. It's case 2024, should be 244. My number's got 24 on the bottom of it, but it's 244. The case at 3508 Foxhole Road. This was an item A appeal, appealing my denial and cancellation of a permit. The applicant's counsel was ill and requested a deferral, and we agreed to that. And that case will be heard at our next meeting on December the 19th in this room at 1 p.m. That's case 244. Let's see, the next case we have is at the bottom of page 3, case 2024-247 Lamar Advertising at 2364 Gallatin Pike. That case has been withdrawn by staff. The applicant's application, they have amended their application since they initially filed, and they now comply with the regulations, so they no longer need a variance. And then at the top of page 4, Henry Jahola, the owner of the property at 213 B Rising Sun Terrace, he is also deferred till December the 19th. So if you're here for cases 248 and 244, those cases will be heard December the 19th at 1 p.m. in this room. And then again, case 247 has been withdrawn. With that, we'll go over the Next series of announcements. The next one that we have is a case that is tied up on votes. It's in the middle of page 2 of your agenda, case 2024-239, Colin Moreau. This case, public hearing is closed. You have made a motion to approve. That motion was made by Mr. Pepper and seconded by Mr. Cole. Those two gentlemen voted in the affirmative to grant the case. Mr. Bradford and Ms. Carpenek voted against granting the case of variance, and there are 2 members eligible to participate, and I'll poll each of you individually. First beginning with you, Mr. Ransom. Have you watched the video and looked at the case record, and if so, I guess I need an answer on that, A, and then B, do you wish to participate and cast a vote?
I watched, unfortunately, only half the video because I was also watching the video previous to this case 2025, which was a little over an hour. So I ran out of time, unfortunately, for case 239.
Okay. And Mr. Ransom will not be eligible to participate. Ms. Johnson, were you able to watch the video in the case? And do you wish to participate on case 239?
Yes to both.
Okay, and you vote, how do you vote in case 239?
239, I vote no. The reason being is I was not, the information provided was enough to convince me of the safety of the Ohio Avenue side.
Okay. Ms. Johnson, your vote will be recorded as a no on this vote. Mr. Ransom will be marked as absent or not participating. Just double checking my notes here. This case was heard on November the 7th, and so not having 4 affirmative votes within 30 days of this application, the application case 2024-239 will be denied by operation of law, and the appellants will have 60 days to appeal the board's denial in this case, and an appropriate order will be entered as such on case 239. And then with that, I did skip over the first case, case 2024-225. Paul Simiu is the appellant of the property located at 1532 Neely's Bend Road. This case was deferred by the board in order to allow the applicant and opposition time to speak. In reviewing the record, I noticed, Mr. Chairman, I believe that the board did offer or entertain the ability to open the public hearing, but before doing so, for a brief set of time, I do recall, before doing so, I'll poll Mr. Ransom again. Have you watched the proceedings in this case? And
yes.
Are you eligible to participate?
Yes.
All right. Mr. Ransom will now be eligible to participate. Ms. Johnson, same question for you. No vote has been, motion has been made on this case. So just, are you able to participate in this case by reviewing the record?
Yes to both.
Okay. The record reflects that both Mr. Ransom and Ms. Johnson are eligible. Mr. Chairman, we'll have that'll be the first case before the board today. And I guess the first decision the board needs to make is how much time to provide either side to find out what has occurred since our last meeting. Yes, sir.
From what I saw, it seems like 5 minutes would be enough because I think from what I could tell.
Agreed, 5 minutes will be sufficient.
All right, Mr. Chairman, the public hearing will be reopened for case 2024-225. Is the appellant present here? Okay, they are present. Opposition, I do see present as well. If the applicants wish to come forward at this time, you'll have 5 minutes. That clock to your, I forgot to say this in the beginning, all parties that come to speak before the board, you'll need to identify yourself by name and address. And to the right of where you're sitting will be a time clock that'll keep track of the amount of time that you have remaining to speak. Gentlemen, as we talked about in the first one, because this hearing's open for just 5 minutes, you may want to save, up to you, a portion of your 5 minutes for rebuttal. and I will begin the clock after you're done introducing yourselves.
My name is Philip Margetta. I'm a developer and come again? Yes, address is 1115 57th Avenue North in Nashville, Tennessee. And a lot of the times when we come here, we usually ask for more density. In this particular case, we're actually asking for less density. We're asking for a special exception to build 2 homes because we believe that's more in line with the neighborhood. And we've met on several occasions with the neighborhood. We're unable to come to an agreement. But I think granting special exception would actually be in favor of the neighborhood because it would allow less density than what is currently allowed with the current zoning. No, we presented different elevations, different materials. None of them were met with open arms. I think the neighborhood's goal or hope is for us to just abandon it and the lot to never be developed. I don't think that's realistic, but I think that's where the opposition stands. Yes, so I can speak to that too. It was height and architectural style. There's no architectural consistency on Ely Bend. The height, from what we could measure from the street.
What is y'all's height going to be? Remind me too. Is 30 something?
Hey, my name is Paul Simi. I'm at 3020A Richmond Hill Drive, and the height on our plan was 34 feet and 11 inches. We do have the ability to modify that if the board finds that appropriate for the neighborhood. If they say, hey,
How much can you modify it? How much are you willing to modify it to make this still economically feasible and practical?
we'd be willing to modify by a good bit. So if that meant, hey, 25 feet, 30 feet, whatever it may be, as long as we're able to do a story and a half, I feel like that would be appropriate.
Did you talk with the neighbors about being able to limit to 25 feet, and did that make a difference with them?
Yes, so that is something of discussion that came up, and we offered, hey, could we do, or would you guys be more open to us doing something smaller in scale than that height? But it seemed like that was one of a few different issues that they had. So whether it was architectural, whether it was the height, whether it was front to back, there was rebuttal based upon every single argument. So there is something that we're willing to modify and change. If the height is a problem, we're willing to do houses that have smaller massing. But ultimately, based upon our discussions, it was more than one thing. It was the height, it was the architecture, it was how the homes were on the lot. But we are willing to do and change pretty much anything of those two, of those three arguments, except doing a front to back home. We're willing.
Okay, thank you.
Chairman, may I ask a question to the applicant? In this document you have submitted, I did not see any new information, if I'm missing. I think at the November meeting, several members suggested it would be helpful for us to determine your point. It's like you're saying height is comparable, but you do not show us each height of the house on the picture or drawing. And it would be helpful for us to see if the frontage, the width will be compatible with surrounding neighborhood, but I have not seen any of those drawings. Have you prepared those drawings for us to show us as evidence?
So at the last meeting on the screen, so we were not able to get the heights of the houses around them, but the majority of the houses around are 2 stories. There are a few that are ranch style. I believe the house next door is 1.5 stories under the gable. So we figured coming here today, say, hey, we're willing to modify the height as long as we get a minimum of 1.5 stories, which is less than what you see in the neighborhood. We felt like that was a good fit. So most of the homes here over that surround this home, they're 2-story brick homes, and we're willing to do 1.5 story. Not really speaking too much as to what the mixture of siding materials is, but we are willing to modify it so it would be less in massing and height than what the majority of the neighborhood is.
I do appreciate the willingness, but what would be helpful for me personally is I'm a visual person, and when I served on the Historical Commission, it was up to applicant to bring those drawings to show each house. This is the house surrounding in that area, and this average is, say, 30 feet. So therefore, what I'm proposing at 32 feet is not too much. Or the surrounding area frontage is about 80 feet each. So what I'm proposing, 75 feet, is just a bit smaller. Those kind of evidence will be very helpful for us as a member to determine if it's compatible and it's not out of the scale. But so that's what I was hoping you would come front of us to prepare, because it's up to you to convince us what you're proposing is reasonable and, fits in the general plan.
Yes,
So-
ma'am. Any other questions? Looks like is the clock still running, or?
Well, it was stopped because when you answer questions, that doesn't count against you. So
Okay.
you still have 4 minutes and 25 seconds.
Okay.
You
Well,
have to use
I'll
it.
add to the plans were shown. I don't know if we showed them at the last meeting, but we brought the plans for every single meeting that we had with the neighborhood. So the neighborhood has seen the plans on multiple occasions, renderings.
I will say that though, what seems to be the issue here ultimately between the opposition, us, and based upon the CN zoning of the lot, is that the lot by right, it allows for multifamily. So it means that there's a minimum amount of units, which is 3 units that we're supposed to build on this parcel based upon the site plan that we had proposed. 6 to 8 is what we were gonna do originally, but we decided to come to the board based upon seeing what's in the area. And we personally thought that doing 2 units was better contextually in the neighborhood than putting up 6 or 8 attached or detached townhomes. Now, there is a height limit within the base zoning, which is 20 feet, 1 or 2 stories. So if it came to it that we had to abide to the height limit, we could still do that. But ultimately, the issue here was by right, it allowed for multifamily, and we wanted to do 1 and 2 family.
Any more questions for the applicants? Sorry.
I just have one for Joey.
Oh, okay, all right, yeah, good.
Hey, Joey,
Yes, sir.
and I think this was briefly discussed, so if I missed it during the previous meeting, forgive me, but, I know there was some language change, allowing properties in this location to have, preferably 3 to 8 units. Was that within one structure, or is that within multiple structures? Like, for example, you have 8 townhomes, but that's 4 walls, 1 roof?
It could be multiple structures.
It could be multiple structures?
Yes, sir.
So, assuming it fits within, the lot was big enough, you could have, in theory, 8 separate structures if you met setbacks and everything else?
You could, yes, sir. We would see 8 individual, let's say, townhome style development. That would still be multifamily for us in the zoning code, because we look at the number of units per lot, per property, if you will.
Okay.
Members, I do have additional information to add since our last meeting has occurred.
Thank you.
The council member has introduced and has had passed Council Bill 2024-570, which rezoned these 3 properties that you see on the map. It's the parcel in red, actually 4 parcels. Parcel in red and the parcels, 3 parcels south from CN to RS15. Now, for the purposes of this board, I stated today in telling you as zoning administrator is my opinion that based upon state law and Senate Bill 559 that this rezoning has no effect on the application before you today. State Senate Bill 559, which was listed as Public Chapter 453, was passed by the legislature that says the General Assembly declares that property owners should expect that the merits of a permit application be judged on the law in effect at the time of the application. The interest of property owners to use their property as they see fit, free from the threat of interference from potential local regulation, outweighs the need of a local government entity to work out the details of a potential zoning change free from possible violations. To this end, the General Assembly rejects the pending ordinance doctrine described by the Tennessee Supreme Court in its May 14, 2007 opinion in the case of Harding Academy versus Metro Government of Nashville and Davidson County, and declares that the doctrine is contrary to the public policy interest of property owners in this state. So as I spoke with the council member earlier today, she had asked about the rezoning which took place and was signed by Mayor O'Connell on November 20th. That rezoned this from CN to RS15. I told her it would be our office's policy to enforce the state statute. So it will have no effect on this gentleman's application. It would have effect on subsequent applications on the property, would be treated as RS15, that this use would not be allowed. So I give that to you as in the record of this case so that you understand that there have been substantive changes to the situation overall on the property. Since our last hearing was November the 7th, yes, sir.
Okay, any further questions for the applicants? Okay, thank you, gentlemen. We'll hear from the opposition.
And applicants, you'll have 3 minutes
Yeah,
and
you'll have
14
rebuttal.
for rebuttal. Good. Now, the board will now hear from the parties in opposition to the case. So, Counselor, you're here. Let me reset the clock for you. Again, you've been here several times, so you're familiar with the process, but we won't start the clock until actual testimony. So if you guys would like to introduce yourselves to the board.
Hi there, my name is Jesse Strauss. I am at 1627 Pawnee Trail in Neely's Bend. I'm here speaking on behalf of the Rural Neely's Bend Neighborhood Association. I'm the president. We were here a couple years ago when we heard a subdivision down in Neely's Bend, and we're grateful for you visiting Commissioner Johnson and seeing our cows and taking the time to understand the character of the neighborhood. I just wanted to start where we left off a month ago. Our understanding was that we had a strong directive from the BZA to take the past month to meet with the developers and find a compromise. I will say we took that directive very seriously. We set a date, the day of the hearing, November 18th. Did move through with that. And both Paul and Philip visited. But unfortunately, they came with zero ideas. I think the only idea for compromise that they had was to buy, for us to buy the property for $275,000 from them. And they said that would only be $10,000 per resident. That was at the last meeting. So I would argue that as the construction experts and development experts, it is on them to at least come with the creative ideas of what could be done in all of the possibilities. And as you mentioned, Ms. Johnson, they have not come with anything concrete, no photos. I will say in that meeting, we, in the spirit of compromise, tried to think of every possible outcome. And we could think of three. One was to change the orientation to front and back. So you have a house in the front, which is more similar to the character of the area. Two was to put multiple units under one structure. This was a suggestion of someone else on the commission last month. I thought it was a good idea. Again, it fits within the spirit of CN zoning. But it appears as a single family home, which is what the neighborhood is primarily. And then the last was to have different designs for each home, so they're substantially different looking and don't just appear like two mirror images. Now, the only thing they were willing to entertain was the third option, to have different designs. They said they would send that to us. We did get images, and I can show them to you now. They are the exact same home, mirror image. One is with brick siding, one is with, a different colored siding. So even the one option of the three that we came to the table with that they said they would entertain, when we got that, it was not even what they had promised that they would share. They said that they had, Paul said, I have actually a different design with the same floor plan. That's no problem. I can put it next to the other design, and there'll be, stark difference in appearance. So I guess I just say that to say that with your directive to find a compromise, we did the best we could, and the different color homes was just not enough for the community when we passed that to them.
Jason Holman, 42 Tim Park Avenue, on behalf of the neighbors. And there were no heights depicted in what was provided to you, correct?
Correct, nor in the blueprint that they submitted and shared with us, no heights.
Okay. First, I want to say to this board, what Mr. Hargis said is correct in that the law has changed and this property is now zoned RS for single family. So if this application is denied, I think all parties are in agreement that it's not going to be built as multifamily. It's going to be built as one single family house. Now, I have a disagreement with the zoning administrator as to whether or not this board actually has the authority to proceed at this time. The statute that was cited to you is a denouncement, so to speak, of the pending legislation doctrine, which was actually my case 17 years ago. The pending legislation doctrine says that if a zoning bill is pending, you can't withhold permit issuance while that is pending. You have to go with what the law is in effect at that time. It was in the context of an historic overlay pending, and could demolition permits be issued. I don't read a state law that rescinds that pending legislation doctrine as saying once the zoning has happened. So what's different here is this rezoning has completely come into effect as of the end of November. I believe that you're obligated to follow that law at this time. And the only other statute that addresses this situation is the Vested Property Rights Act, which was adopted in 2014 and changed the law, whereas before you used to not only have to have a permit, but you had to have a permit and action in furtherance of that permit, like construction had begun. The Vested Property Rights Act changed that and said, no, if you have an issued permit of these types, then you can rely upon that regardless of a change in the law. However, a special exception permit is not one of those enumerated permits. It's a building permit, which couldn't be issued until after this occurred, a development plan, a preliminary plan, or a final development plan by the Planning Commission. So I believe that both because a renouncement of the pending legislation doctrine is not, in fact, applicable to this situation, and because the enumerated vested rights that you can get through permit do not include a special exception permit, that you're actually without the authority to do this today. But nonetheless, as you heard earlier, the neighbors tried to work. It is their burden to prove, and there is nothing that's been submitted to you about actual heights. Thank you.
Thank you. Any questions? Okay, thank you, gentlemen. We'll close it.
I was slow.
Oh, wait,
Sorry,
Ms.
I was
Carpenter,
looking
go
at them
first.
first. So we did hear a proposal for a 25-foot high, 2 homes. What do you all think about that?
That was never mentioned to us. I don't know what that was about. Yeah.
Well, what do you think about it today?
Well, I think that, it fits within the concerns of the neighborhood about the height of what was in the proposal that is in front of you, but I have concern just based on past meetings where they said that they would do one thing, send us, a sketch of what the homes could look like, that if we're just taking them on their word, and I don't have anything to look at to compare it about, I don't know how to give you an affirmative on just a height alone.
We could assure you, if we give them a special exception with a limitation of 25 feet, they're going to have to build within 25 feet, or they're going to risk having to tear it down. So if you could be assured it would be limited to 25 feet, would that be okay with the neighbors?
Sorry. Yeah, what I have heard from most of the neighborhood is that they don't want 2 structures on this property. If we're trying to find a compromise, if it was 25 feet and it was something like a front to back orientation, or it was under one structure, I think that would certainly be better than the proposal that is in front of us.
So reducing it to 25 feet would not take care of all
Not
the
alone.
concerns they have about compatibility.
Yeah, not alone.
And I'm going to follow up question to clarify. You kind of said contradictory. You said their concern is having 2 units, but you'd be okay with 2 units if they're front to back? So, or is the concern 2 units left to right?
Again, trying to find the center ground, I think that if there has to be 2 units and that is the only option, then the question that, you know, I would pose to my neighborhood is how can we have 2 units and it still appear as if it fits within the character of the neighborhood? Having them as they do, which are side by side, very tall structures, you know, even if they were 25 and side by side, and you look at the homes that are surrounding the property, I don't think the height change the height change alone would be enough. If it was 25 feet and front and back, or, you know, there was something under a single structure, that would be better. But again, I'm hesitant to say anything with an affirmative unless we are seeing a design just based on my experience with the developers to this point.
Okay, thank you.
Okay, I think that's all the questions. Thank y'all very much. We'll close the hearing and discuss. I mean, oh, I'm sorry. Gosh, that's right. You guys have a rebuttal. I apologize. You have about 4 minutes left, applicant, so 3 minutes, or I think they have 4 minutes, don't they? 3 minutes, 3 minutes and 14 seconds.
Well, Sammy, so I wanted to speak on a few things because ultimately over the past month, what we've experienced has really been moving the goalpost. So originally, what the problem was here was, hey, you guys are wanting to build these 2 houses. We don't like the architecture of these homes. So we decided to make colored renderings of the designs that we had. And when we had our meeting, I think it was November 18th with the community, with those 3 options that he had proposed, I specifically said I will change the exterior materials of the homes, the colors of the homes. I sent 6 to 8 different renderings that I had made for, that I paid for, to the opposition. And what we got told is that they don't like what we had put together, period. They didn't like that our homes looked like tall and skinnies and that they didn't have enough separation between them. The thing is, if we offered them what they had asked for, which was more separation between the homes, there would be actual tall and skinnies. So we feel like a lot of the discourse that we've had between us and the opposition has really been moving the goalpost, because a lot of the stuff that we've gotten rebuttals from, such as last time we were here, they didn't want to see a lot of density covering this lot. Well, if we build a front to back home and we have to have a shared driveway that goes to the back of that lot, we're gonna have more density on this parcel. And something else that I wanted to bring up as well is that obviously the councilman here has rezoned this parcel. The owner had no idea of it until I let them know this morning. There wasn't any signs on the property. And beyond that, something that was brought up in our first meeting was instead of us doing residential here, why not we do commercial? Now, there is something that the previous owner or the current owner had in mind for the property, but that right has now been taken away from them. And in addition to that, on the rezone application, the council member had put on there that she did not want any commercial uses. So there's been a lot of things that we've, like we had said, that we've been told one thing, we try to make it work for that particular situation, and that just doesn't happen. Or there's a different objective that's now brought up that has nothing to do with what we originally want to do here. So ultimately, we are willing to do whatever we need to do to be able to put 2 homes here that fit in a nice architectural style to work with the neighborhood. But it seems like ultimately there wasn't really going to be any sort of compromise made on this based upon the merits of what we've discussed, what we've talked to with the opposition, and what the community has told us.
Would you elaborate on the front and back 2 housing option? You touched on it. You discussed, and why are you rejecting that idea of front and back? And if so, why?
So ultimately, we really don't think a front to back is really aesthetically attractive, and that's not something that you see in the neighborhoods. There's no homes in the neighborhoods where there's one behind another one. And if they would like a front to back option, then the opposition saying that there's an issue of density and runoff and having a bigger lot coverage, that really isn't an issue if they're wanting front and back. So I come back to what I was saying about moving the goalpost is if I say, okay, we're okay doing front to back, there's going to be some other issue that's brought up for that. So is that something we could do? Possibly. But it seems sort of hypocritical if front to back is the answer, but we're also being told that there's concerns about density on the lot and the lot coverage as well. If you have two homes that are side by side that have one shared driveway down the middle, you're going to have less lot coverage and density than you would having two front to back homes.
I have just a couple quick questions. You know, in regards to special exception, you know, you've got the integrity of the adjacent areas and design and architectural compatibility with the adjacent areas. And this is in a pretty rural area, and, you know, it's tough to kind of put a nail on the head of what kind of architecture this is. Kind of looks Dutch Tudor with very high-pitched roofs, you know, that comes from Europe where you have a lot of snow, so you need a higher pitched roof. Are there other buildings in the area that are in this same architectural vein? Because, you know, a lot of what I'm hearing from the previous meeting and this one is people's concern with the height and then the style of them fitting in the area. And I think, to me, a lot of those things could have been absolved with a different architectural style and maybe making them less and then not mirror imaging them. Because you often hear about tall and skinnies and people fear them for whatever reason in their neighborhoods, splitting lots and increased density. So I feel like there could have been some things that could have been done from an architectural standpoint that maybe would have pulled these neighbors more in support as opposed to you guys. So I guess going back to my original question, where else do you see anything that matches this architectural integrity within kind of the adjacent areas?
So this neighborhood, primarily most of these homes. So this neighborhood, primarily most of the homes were built between the 50s and the 80s, I'd want to say. So most of them are two-story colonial style homes. So there isn't a set precedence for it. There is a precedence for two-story homes, but there isn't a set precedence for maybe the exact design that we have. The house next door, I believe it's 1.5 stories under the gable. It doesn't really have any sort of design preference. And the house on the other side, I believe that's a 2-story. Or that one's a 1.5 story, so that's also under the gable as well, that has big columns in the front. It's more so a colonial style. So we didn't want to do something that was super modern in this neighborhood. We wanted to keep it architecturally at least somewhat close to consistent with what we see here. And in addition to that, when we had our meeting on the 18th, we said, hey, all the homes here, they're all brick. Most of them are unpainted brick. We're willing to make our homes unpainted brick. If that's the case, or change up the siding materials. And that's something that we did receive positive feedback to. But ultimately, like I said, a lot of what we've experienced is moving the goalposts, where if we say, is this what you want, we go told yes, then something else becomes an issue. So ultimately, if architecture is a problem, we're willing to do whatever we need to do to make that not the problem. But we haven't really been told what way to really go about doing that, because we get told that there's 5 different things wrong with the house, and we try to give a solution to each one, and then something else ends up coming up. So that is something that we are willing to work on if it's a problem. But like I said, it's hard for us to work towards a solution, and we don't know exactly what people want to see here.
I have a question about, I guess we're just going down the line here, about the suggestion that there be multiple units in one structure, like a true duplex. What were your thoughts on that?
So my thoughts are that's not something that we're really wanting to do. Like I said, if that's what people want to see, it's possible. But coming back to what the rebuttal had said about it looking like a mirror image, if you build a home that's a duplex, that's mirrored, the left side looks like the right side, then that's exactly what they don't want to see, right? So that's something that there's not really too many duplexes over here, of course, in Neely's Bend, so there's not really a precedence for it. It's something that could be discussed, but ultimately it's something that would probably be against, because what you see in Neely's Bend are freestanding homes. You don't see duplexes where there's 2 doors on each side of the structure.
I mean, getting into the weeds of architectural, you could do like an American 4-square style house with just 2 front doors. Like, there's ways to make it look like a single family house, but I know that changes metrics, and from a family standpoint, you want separate buildings, backyards. So,
And And it would be one structure, but it would still look like two homes. And the neighborhood before has expressed concern about how close the homes are to one another. If we attach them, I mean, that's as close as they could possibly be. So that would still not, it would still look like two homes, even though it would be one structure.
Thank you.
No other questions? Okay, thank you. Now we'll close the public hearing and discuss. Oh, council lady, okay, yeah.
Hello, everyone. Good to see you again. Welcome. Ms. Johnson, I would like to repeat a few things.
If you could state your name.
Yes, Tanya Hancock, Metro Councilor for District 9 in Madison. I'd like to restate a few things that we mentioned last month. Ms. Johnson wasn't able to be here, and it answers one of the questions she asked early on. This is in the T2 rural maintenance policy, so the area that a lot of these members were in this room for a planning commission hearing about 2 years ago. The proposal was, ironically, to build homes that would be on lots as small as 0.58 acres, which is the exact same size of this particular lot. We can't change the size of the lot, I understand that. So what I did do is I added up the size of the lot 5 up the road and down the road from this particular unit, and the average size of lot is 4 acres. So 70% of that, which is typically what we do in a neighborhood maintenance area, is 2.8 acres. Again, we can't change the size of this lot. So looking at the road front footage, which you asked about earlier, the average road front footage on this side of the road, 5 up and 5 down, is 202 feet. So 70% of that is 141 feet. This lot is 80 feet road front footage right now. We can't change the size of the lot, but we are already at 80. And so this particular design has 40 feet per home, just a little bit less if you consider the shared driveway, which is hugely different than anything else on the street south of the Neely's Bend schools. So the concern that I had when this developer first contacted me the day after the zoning was changed by a council member that intended to have this CN allowing multi-use housing on major thoroughfares where there's easy access to public transit, was not intending the CN that's on the end of a dead-end road in a rural area. So right after this zoning was changed, I was contacted by this developer, and my first suggestion was, would you consider building them front and back? And they said, well, we hadn't thought about that before. Maybe we could think about that. But at the neighborhood meeting, the first neighborhood meeting, it was said absolutely not. And at the second neighborhood meeting, when that was brought up again, it was said it would be too expensive to run utilities that far, as well as the land that would be taken up would reduce the runoff. But I mean, if you're building the houses wider and front and back maybe, but I would think you would have land on the sides that you wouldn't have before if it was front and back. The reason the neighbors had suggested front and back is because then when you're driving down the road and you all of a sudden see a small 80, road front footage, it's not as startling as seeing 40 in the rural maintenance area at the end of a dead-end road. The assumption that the goalposts are moving, I think, is not necessarily that they're moving consistently throughout all 80 to 100 families that have participated in this process. Everyone has said, yes, we would be willing to grant a special exception for one house on this CN lot. Everyone has said, yes, we would be willing to grant a special exception for a slightly higher height if it's one house. But the other suggestions that have been brought up by different individuals, and those aren't as easily adopted by all 80 to 100 families. I would just like to say what was mentioned earlier about the zoning change was obviously brought forward to council by me because of this change in allowances in CN that wasn't intended for rural maintenance areas at the end of a dead-end road, and also because of the consistency from this particular project of the promise that, well, if you don't allow this, we will do this instead. And like from meetings too on Facebook, saying, hey, well, we can just do that. I felt like I could remove that obstacle and allow you guys the opportunity to say, do you think this fits in a T2 rural maintenance area? Do you think that special exception should be allowed? And I think from, the testimony I've heard from all of my neighbors, they're all consistent and wanting one house. And I would be perfectly fine with you granting that exception to allow that, as well as to allow a higher height than was allowed with that CN zoning. But thank you very much. Do you have any questions for me? Thank you.
Thank you. Okay, we'll close the public hearing and discuss. The legal issue, I have a lot of respect for Mr. Hargis and Mr. Holloman, but this, I just don't have time to digest. There's a debate about whether, because of this zoning enactment, we can go forward. And I don't, that was just brought to our attention today, and I haven't, speaking for myself, I just hadn't had time to look at those statutes or sort it out. It does seem to me like the zoning administrator's interpretation of that seems reasonable. I also think Mr. Holloman has some points, but I'm not going to be able to, I'm going to consider this for myself on whether it meets a special exception or not on whether we have the authority. Mr. Holloman's position is we don't have the authority to hear it. He may be right, but I feel like I haven't had time to consider that or digest it. It's just being brought up. I also think they've got to get 4 votes today, and I think there are probably some, it's, at the very least, to me, it's a close case. I'm a lawyer. I'm not an expert on architecture or design and architectural compatibility, but reading it, it is pretty broad. It relates to building style, height, building orientation, and we're hearing from a lot of neighbors who maybe if I were an architect, I'd feel like putting my, overriding them, but I think that's what I'm hearing is that there's a lot of neighbors who live there, and I don't feel like it's just not compatible. And I do know special exceptions, if you meet the requirements, it's not like a variance, but I think the point they've been making is overwhelmingly that it's just not compatible. And but I'm open to also thinking the seeking a special exception is not the same burden as a variance. So I'm open to hearing everybody's opinion, obviously.
I think, it's upon us to determine if this proposal is under the new Ordinance Bill 2024-187. It says the relief being requested will not be injurious to surrounding properties, nor violates adopted general plan. So this area being T2 rural maintenance, so that I'm big on the planning and zoning and, general plan. So if this proposed design and particularly detached duplex will meet T2 rural maintenance surrounding area is a big issue. I don't want to go into design, but particular proposal is, and that's why I was so disappointed with the developer. It's upon them to present us, yes, surrounding area, they do have this design and they do have this shorter frontage, therefore this proposal will meet perfectly with surrounding, but they didn't do that. So I'm pretty convinced this proposed design does not meet with intended general plan. So that's where I am.
I kind of in agreement with both of you. I'm all for development and density and more housing, and 2 homes are more affordable than 1 large home. But, from a special exception standpoint, the developer needs to, essentially prove prove all those points. And, you know, as a builder and developer myself, there are easy ways you can not mirror image these two. You can make one the prominent structure, step back another one, give them different elevations to make one feel like a subsidiary structure to the other one to fit in the rural area. There are things that could have been done, in my opinion, to, I guess, you know, not only take care of some of the neighbors' worries, but also hit all these points from a special exception. I mean, at the end of the day, our hands are tied if all these points are met. But to me, they're not being met, in my opinion. And I'm going kind of against my own grain. I generally predominantly want more density, but and going back to the earlier point of whether we have the ability to vote on this or not, I agree with you, Ross, that I don't have the ability to make that determination. So I think we have to keep moving forward as if we were going to grant this as a special exception, then let something sort out later if that needs to be the case. So that's a long way of me saying I generally agree with both your points.
If I may add one thing, it's a request to the council body, because adaptive residential use is great, because we do need housing and we do need density. But I think as a general plan, we do have growth and preservation. That's the principle. So if we do not have too much density in a rural maintenance area particularly, so maybe council body can further amend the, adaptive residential use ordinance. So just my thoughts and requests to the council body.
Anything? Okay. Well.
Well, sure. I mean, we're all talking here, so I don't know how I'll vote, actually. I'm looking at the planning department's letter. Staff supports the request to build two 2,500 square foot homes on the property through the adaptive residential process and to exceed the maximum height of 20 feet. So the planning department is actually recommending it with up to 40 feet. So this is really quite difficult, I think, to really decide on this case. And I guess what's before us is really just the special exception to allow less than multifamily housing. I mean, that's what this property is zoned for, correct? With the CN zoning and the adaptive residential, they're allowed to build multiple units, 3, 4, whatever fits, I guess, with as long as it's not above 20 feet high. That'll be less compatible, I think.
Exactly. What they're allowed to build wouldn't meet the special exception.
Mm-hmm.
If they came through here and said, hey, we're going to build X, Y, and Z that we're allowed to build, we wouldn't be able to give them a special exception on it because it wouldn't meet these criteria. So it's a little...
Well, I'm just saying we can deny it and they can go build 3 homes, 20 feet tall, each of them. I don't think that's going to look very good and be compatible with surroundings.
I don't think that's accurate, though. I think that what we heard was that the zoning has been amended.
Well, the zoning before the rezoning. And this is zone CN before November 20th.
Joey, if you don't mind clarifying, previously it was, from my understanding, and might be operating under something that's incorrect this whole time, I hope not, but previously, we could do 3 to 8 units by right up to 20 feet tall. But between that November 7th meeting and now, it's been zoned RS as single family. So now we're no longer discussing about the 3 to 8 option that's off the table altogether?
No, I disagree. I think that is what you're discussing.
Mm-hmm.
So if they leave here,
Counsel for the other side disagrees with me.
Say that again. You think?
No, we're under, from my standpoint, the state legislature's action says it freezes this application in time. It's the same application we've been looking at all along.
Right.
The zone
even
change
though
in
the
my mind
zoning's
plays
changed,
no effect.
because the timing of this application, even though the zoning's technically changed, your interpretation is they could leave here and go build 3 to 8, even though the zoning's changed because of when they submitted the application, is what you're saying?
Correct.
Even though they didn't ask for 3 to 8 in the application?
No, that's what the law at the time the application was filed was.
Okay.
So I think that's the dilemma for me.
So say that again.
That's the dilemma for me.
Is that they can build something that's probably more incompatible. And that's one reason that I thought, well, they needed to have a get-together, and, because I thought,
Right.
I know they were getting good advice from their council, but I just thought they needed to rethink, if this doesn't pass, what might they end up with? And, but they've had that opportunity
Who knows?
So I don't know what's going to happen here today. I just think it's a difficult.
Well, let me clarify a little bit. What they've applied for are 2 units. If they come down with another application for 6 units, I'm going to turn and go, sorry, that's not allowed in RS10 zoning. What's frozen in time is this application.
Okay.
What's not frozen in time is the law at the time the application was filed. What's frozen is this specific application.
I got
So
it. So
If they come down now with 3 units, I'm going to say, no, RS10 doesn't permit 3 units. Have a nice day.
got it. Okay.
But if that legislation didn't change and this application was denied, then by
Correct.
right, they could build the,
Back at that time, yes, ma'am.
okay, thanks for clarifying.
Yes.
Okay. So then, okay.
Yeah, does that help?
No, it's a good question because I wanted to clarify for everybody what happens next, whichever way this goes. If it's approved, tied on votes, whatever, all that's before this board is this application.
Right.
And I take a screenshot, in essence, using phone terms, I take a screenshot of the law at the time this application was filed, and that is the law applied to this application. If the application changes or, withdraws or dies or voted down, then whatever the law is now is what we apply going forward.
Okay. I'm crystal clear now. That helps a lot. I think when anybody comes before us for a special exception, I think they need to go that extra mile. To me, on the surface level, this kind of looks like your typical kind of HPR split lot, mirror image type of situation. When you're asking for a special exception, you've got to work. And to me, you go that extra mile to do something that really checks all these boxes. And
Especially when you're in a rural area, I think.
even more so. And it's not, I don't think it's necessarily anything, they're the ones asking for the special exception. I don't think it's necessarily anything onerous. I think it could have been achieved in this case. I think from my read of the situation, I think most of the surrounding neighbors just generally don't want 2 units on a smaller lot because sounds like it's fairly out of context. But to me, I don't think they've checked all the boxes, in my opinion, which is unfortunate. But
Was that a motion? Or can it be a motion?
Sure, I'll have my first motion be something I don't want. I make a motion to deny the applicant's request for a special exception for not meeting all the criteria
Okay,
laid
I'll
forth.
second that motion. Okay, so there's a motion and a second. Any further discussion? All in favor? All opposed? Okay, so that application is denied. All right, next case.
That application is
Anybody-
denied on a vote of 4 and 0. And then,
Was it really?
okay, ladies and gentlemen who are present, if you would please just depart as quietly as you can. If you need to have conversations, please do so out in the hall. Okay, ladies and gentlemen, members of the board, our next case is actually new business. But I've lost there we go. Okay, the next case in front of the board will be case 2000, actually listed under old business, but it would be at the top of page 2. Mr. Michael Mills and Belinda Mills of the
Is this
appellant.
229?
229, yes, sir. And I've lost my signal here. Bear with me 1 second. while the Millses come forward, are there any parties here present in opposition to case 229 at 1411 McKinney Avenue? Okay, Mr. Chairman, we'll see none. Mr. and Mrs. Mills, I'll go through the case record first.
Okay.
You guys welcome to have a seat. And then once I'm done, I'll turn it over to you all, and you'll have 5 minutes
All
to
right.
present your case to the board. Don't know why I'm having an issue with the video, Mr. Chairman. Mr. Chairman, can we take a recess, please, sir?
Sure.
So I can figure this
So
out.
We're gonna take a 5-minute recess and deal with some
Hey, is there
technical
a
stuff.
restroom anywhere near?
Oh,
You
all
can
right.
wait there, or you can
Is there a
move around.
restroom?
We'll just start back in about 5 minutes.
Is there a restroom there?
server room.
Your server?
It's our server room. When I walked into our office, I thought everything was falling apart.
Well, was it the server malfunctioning?
I don't know, I'm getting like emails about it right now, because I was the only one there and I'm not the tech person, so I'm gonna read those emails while I have this break.
I'd say maybe you need a new server.
They're gonna do something about it, but it was like, I didn't know what was going on. No, it's not gonna load. So it looks like we don't.
Yeah, I'm only getting one bar. We've got like 8 more on the docket, but this is all we have, so I was.
Michael and Belinda Mills are the appellants and owners of the property at 1411 McKinney Avenue, requesting a variance from the fence height provisions and street setback requirements in our R6 district. The appellant has constructed a existing fence there, referred to the board under section 1712-040. The appellant's alleged jurisdiction under section 1740-180B. Are there any parties present in opposition to this case? Mr. Chairman, seeing none. Mr. and Mrs. Mills, I'll go through the photographs first and present the case to the board first.
All right.
This came to the Codes Department's attention via complaint through our request for service system at 1411 McKinney Avenue. The fence that was constructed is too tall where it is located. Overall, in the front yard, it is too tall by 2 feet. It is an 8-foot tall fence. The maximum permitted height of a fence in the front yard is 6 feet. And where it's located, which you'll see in the next photograph, it's too tall where it's located. And my notes under the height says where it is currently located, the maximum allowable height of this fence is 2.5 feet tall because it is a solid fence. I give you this graphic. This is a graphic we hand out to applicants or when we get questions about building a fence, on solid fence in Davidson County. How tall can it be? In the graphic, you'll notice our lot line or the street right of way out there, that area at the bottom, which is noted. I'll show you my little laser pointer right here. This 10-foot area, you can build no higher than 30 inches or 2.5 feet. Once I clear that 10-foot area from that portion all the way back to the front plane of the house, we allow up to 6 feet in height. The fence can be located on the property lines on the side. There are no side setbacks for it. It can be right on the property line. We rely upon the property owner to, that they're telling us the truth where their property line is.
Right.
And then
Is that accurate even if there's a side street?
No, sir, it's different on a
Okay.
corner lot. The Mills's lot is an interior.
In the middle of the
is a middle
street.
kind of middle of the block type. So this graphic works for their type lot. And then once you clear the front plane of the house, you can be up to 8 feet tall with a privacy fence, all the way to the rear lot line, up to 8 feet to the property line. And so the required street setback, I've got noted here, it appeared to me it's less than a foot. There appeared to be some survey stakes or something, marks, flags, something out there when the contractor they hired to build it built it here. And then the height of it is 8 feet. And so this is a photograph of their fence that you see from a view from McKinney. And upon my visit out there on the 18th of August, although it's true I did take this photograph sitting in my car, I did get out just to stand up beside it to see how tall it is. I'm 6 foot tall, so it was, I could reach my hand up to get to the top. So it's approximately an 8-foot fence. They have offset the fence a little bit. You'll notice here on the left-hand side with a gate to let them get their car off the street and up there. But the reasoning for the zoning code requirement is so the neighbors on other sides are able to see past a solid fence. So it was turned into our property standards division. The property standards division probably sent the Millses an abate letter and given them so much time to either correct or file an appeal. So an appeal was filed, and Mr. and Ms. Mills are here today. That's our case, and Mr. and Ms. Mills, I'll turn it over to you guys. You'll have 5 minutes to present your case to the board.
We didn't intentionally break the codes. When we went to the Cowboy
I'm sorry, ma'am,
fencing company,
did you say your name for the record?
Belinda Louise Mills and my husband Michael T.
Okay, and can you
Mills,
give us your address for the record?
1411 McKinney Avenue.
All righty, thank you.
When we went to the Cowboy fencing company, they hurried us along to get the money in place to build the fence, and I didn't have time to read their paperwork. They didn't follow the codes. They don't, and then after you contacted us, I recontacted them, and they said they weren't liable, and that's in their contract. We didn't do this intentionally. We're doing it for protection. We are being harassed day and night about five and almost a half years ago, they wanted to buy our property for $1 million, and we told them no. My husband is a decorated Air Force officer, Vietnam vet, with a master's degree from the Air Force Institute of Technology, and he did not want to move. We've moved 34 times. He's losing his memory, and he needs to be in a home that's familiar to him. Yes, we could have taken the $1 million and gone up to the lake where we have 18 acres, but there's his feelings to consider, and my respect for my husband. We have everything we need in 10 blocks. They have crippled me over this period of time. I could walk before, now I can't because they were on our house day and night, keeping us up all night and all day. Now they're putting poison in our chimney and down and in our air conditioning heating. Perfume, pesticides. Lately it's been quick freeze, which is extremely toxic, and other chemicals that I can't identify. We were told to move. We were told I couldn't be in the front yard, that I need to be in the backyard. And I'm sorry, I'm not a criminal. We don't have criminal record. We've been vetted by the FBI 4 times. He is a nuclear weapons specialist. These people are, this gang that is ruling East Nashville is out of control. They're determined that they're going to eliminate us one way or the other. This morning, from 9 o'clock till the time we left, they were pouring quick freeze in our house. Through there's cracks in the fence, so they can spray it through into our air conditioner, and then they go and get on our roof and pour it down our chimney or spray it down our chimney until it chokes us, and we have to open the doors and let fresh air in. They have put a hole in the roof. This is a 3-year-old roof that was $40,000. They stole 2 ridge poles. Tony Lane has stole 2 ridge poles. They tore off the gutters. They have burned up the chimney, burning fire, charcoal, wood, charcoal, a whole bag of paper towels, whatever they can get their hands on. And now it's the chemical elements. The smoke didn't work, so now they're down to dangerous chemicals. I was a gardener until I lost my ability to walk. We have flower beds in the front. They've taken all of our plants. I want to redo my lawn, and I want to be able to enjoy my front porch, and I want to be able to enjoy my little dog outside running around like you should be able to do, and I would like to be able to get in my yard without having permission from these violent gang members that will not leave us alone. I am not going to go back to Oklahoma. My book is mine. I wrote it. It does not belong to the 2 Jewish persons that are at the bar, feeding them a pack of lies. I have people on my roof day and night, and some are innocent. They've listened to these people. They've sent them over there. They don't care if they get arrested. If they get arrested, that's on them. Then they have to pay the fine. I'm just tired of dealing with this. I want protection. I don't want to be a party to a drive-by. We do plan on taking our siding off and insulating underneath the siding because they didn't take care of it before, and painting it would not serve the purpose. It's dry rotted. And so that will, we were now $21,000, well, $800,000 now behind, because, well, even $22,300 because of having to put up the $21,500 fence. We need it for protection. If we lower it, they'll just put a ladder up there, and they'll be in our yard constantly. We're going to have to even go to even further.
Ma'am, I'm sorry, I got to stop you. You're at your 5 minutes.
Okay, I'm sorry.
And does anybody have any questions?
I don't mean to be offensive. No one has said anything about the fence but Elaine.
Okay. All right, well, we appreciate it. There are no questions, so we're going to close the public hearing and discuss. There is no opposition, is that correct? Yes, no one present. Okay.
I sent out 200 letters.
Thank you. Well, I mean, it's not having to pull a permit before you get a fence is something we've
Well, she
created
said
lots
that
of work. Ma'am,
Christie
I'm
said they were
sorry,
gonna
at
go
this
to the
point-
board.
At this point, the protocol is that the
Okay.
public hearing's closed, so we're going to discuss it amongst ourselves. I feel sorry for the applicant that they're having these issues with these people that are apparently, but I think that's a police problem to solve, and I just don't think there's an exception in the zoning code for being able to build things that are not permitted as a matter of self-protection. I think I understand why they're doing it, but I think that's what the police are for, and I'm struggling to find a hardship. I don't think we're allowed to consider things that would be considered neighborhood issues like gangs and violence as a reason to deviate from the zoning code. But, that's how I see it right now. I'm open to, I do feel sorry that they have this problem with that they feel like they need this kind of protection. But I'm looking at what our powers are under the zoning code and what a variance requires. I'm kind of at a loss, but I'm open to hearing from anybody else about it.
I agree. Joey, I think, has left the building, but we've mentioned this many times. If the council could pass an ordinance that require a building permit for fencing, this would absolve a lot of issues. We seem to see one of these every single time. And this is from this contractor multiple times, and it just unfortunately puts applicants in a tough situation financially. But unfortunately, they're in place for a reason, generally safety, and it's tough to hear about what the applicant's going through, but we have to kind of stay in our lane. This is related to site work, and I do think there are ways to have a fence that can provide protection and still fit within the regulations put forth by Joey earlier. Still could be tall, but can be semi-transparent, and obviously the other parts are a police issue, but someone could pull out from this corner of this picture here, and if someone's zooming down the street, they may not see them. That's even tough for an alley, much less a main street. So why I greatly sympathize with what the applicants are going through. It's tough to see a hardship that fits within our parameters from a zoning standpoint that would allow this to remain in this location, which is unfortunate. But again, I just wish council, and maybe you could talk to some of your friends that are still there to put something forward that requires a building permit so they quit doing this.
Yeah, I agree, because in this case, what we have to gauge is variance, reason for the variance. As much as I sympathize at the situation, and I think applicant will need to work very closely with the police department and probably with area or council member as well. But it's beyond our capability and authority. So strictly zoning point of view, as much sympathy we have, I think we have to uphold. We do not find any reason to grant a variance.
Yeah, I'll just say I can't find any hardship here. I don't think anybody else can. We have to have a hardship to find a variance. So I feel empathy for these folks, but I'm going to make a motion that we deny the request because as you said, we'd be out of our lane because there's no recognizable hardship here. So I'll make a motion we deny the request.
Second.
Okay, there's a motion and a second.
I just wanted to clarify, you mean like a hardship with the land?
Right, correct. I don't mean, I'm not saying they don't have a hardship that exists. Thank you very much I'm not saying these folks don't have a hardship. We have to have a hardship that has to do with the physical characteristics of the land, and that just doesn't exist, so thank you. Okay, there's a motion and a second. Any further discussion? All in favor? Okay, next case.
Okay,
So
case
what
is
does-
denied on a vote of 4-0. I'll talk to you here.
Okay.
let me announce the next case, and then we can talk about your options. All right, Mr. Chairman, the next case before us is case 2024-245. This is the property at 1201 Bryan Street. Is the applicant present? 1201 Bryan. Well, Mr. Chairman, we will postpone that case until the 19th, since the
That
applicant...
is 245 we're postponing?
Yes, sir.
Okay.
245 will postpone until December 19th. Okay, the next case after that is case 2024-246, Rigoberta Cam at 111 Margaret Street, requesting a variance in the rear setbacks in RS5. The applicant has constructed an existing garage. Is applicant present? All right. Are there any parties in opposition to case 246 present? Okay. Seeing none, let me present this case, and I'll turn it over to you, Ms. Cam. Ms. Cam is asking for a rear setback variance on a detached structure, second detached structure. It's been built at the rear of the property. This is a view of the subject property. This is Ms. Cam's property here. And you'll see in the aerial photographs, there's an existing barn-like structure that sits just to the left of the structure that was built. I'll show you in the photographs. This is a look at the subject property over on Margaret Street. This is over in Madison, just off Neely's Bend, and then the view of the subject properties. And this is, in the upper right-hand photo, is the photograph from 2023. And then this is the structure, I don't know if you can see where my cursor is the structure at question that has been built without a permit and is sitting in the rear setback. We do allow a setback break for structures under 700 square feet. Rear setback variance administratively down from 20 to 3, but the second structure, it has to be built, the second outbuilding that's built has to fully comply with the setbacks of a full 20-foot rear setback. And that's what's in front of you today is the rear setback variance request for the structure there. With that, I'll turn over to the applicant. She'll have 5 minutes to present her.
They need a 20-foot rear setback, is that correct?
I'm sorry, sir.
Is the required rear setback is 20 feet?
It's 20 feet, yes, sir. And then they are, actually the required, I apologize, the required setback is only 3 feet. And on this drawing, there's 3. The building inspector noted that it appeared less than 3 feet.
Okay, so they need 3 feet for
3
the rear.
feet instead of 20, I apologize.
Not 20.
Not 20.
And where are they? Are they right on they're within the 3 feet?
They're inside of 3 feet, yes, sir.
Do we know how much they're inside it?
I don't. There's not been a survey performed, but it was evident to the building inspector that it was inside that 3-foot mark.
Okay.
Yes, Mr. Ray.
So Professor Andrew Joey, just circling back on that comment, the rear setback is 3 feet?
3 feet, yes, sir. And not 20, I apologize for that. Because that structure is under 700 square feet, and I think the zoning in the case, that red structure that's back there, that kind of Dutch barn-shaped building, has actually been back there since the early to mid-'80s, so it would predate the zoning code. So this building, we're treating it as the first structure post-98, needing a 3-foot. Yes, sir. Yes, sir. The 3-foot rear setback is, it's in 1740, 140, 1712, 140. Is accessory structures under 700 square feet get a reduced setback.
No, I know that. We'll talk about it.
Okay, I apologize.
I'm clear.
Yes, sir. All right.
But I'm realizing that sets I thought it was for that particular, I'm clear.
Yes, sir.
Before you go, Joey, one more question. I think it was reference to the material.
Not this case. There was
Okay.
actually another case where materials.
Thank you.
Yes, ma'am. All right. With that, Ms. Cam, I'll turn it over to you.
Good afternoon. My name is Rigoberta Cam, and I
Can
didn't
you
know.
give us your address for the record, please, ma'am?
What did you say?
Your address?
Oh, this one.
No, your address,
Oh,
where you live.
111 Margaret Street.
Okay, thank you.
Okay. I didn't know, like, I need to have permission to to do the new construction because it was damaged on the bottom of the shed. The people who was start to doing this work, I think they don't have idea about the zoning, about the zoning code. And right now where I need 3 feet, I need only right now I have 31 inches. The 3 feet is 36 inches. Just I need 5 more inches. Forget the 4 foot,
So what you're saying is that you're 5 inches less than 3 feet off of that back line?
Yes.
Okay.
I have 31 inches, but I forget the 3 foot. I need to get 5 more inches.
If you bring it in towards the house 5 more inches,
Yes.
you've got 3 feet. Okay, so 5 inches.
I have the picture on the file where I sent to.
Do you have a survey or anything like that? Where are you getting these measurements from?
Oh, from the back.
So you're taking the measurements,
Yes.
and that's to the fence?
Yes, to the fence, to where is the shed, but it's only 31, and I need 5 more inches to
Right.
get the three.
Is this building, tell us about this building you added. Are there concrete footers in the ground? Or is
Yes,
it-
concrete.
Okay, so has concrete footers.
Yes.
It's not movable. You can't.
No, it's not movable.
It's 3'5", yes. Correct.
Okay. Okay, I'm sorry. You can go ahead. I didn't mean to interrupt you.
No, she's got it
W-
from that.
Anything else you have to say?
No. I mean, you can ask her again. but I was also
No,
making the assumption.
and I'm so sorry about that. I didn't
Sorry.
know.
Why don't you pass those up, and if you're okay with it, I think that it might be helpful if we can verify what your measurements are, that you're telling us you're just 4 or 5 inches
Yes,
from being
5
3
more
feet
inches.
away.
Yes.
Okay,
It doesn't look
yeah,
like the
just
shed.
hand those up.
It doesn't look like the shed looks like it's further away. Is it the side setback that's the issue? But if you look at, from this picture, it looks like the shed doesn't go past, by a survey would be.
I'm sorry, I'm not speaking good English. I'm trying to.
Oh, no, we just have some questions. It's easier for us to understand it when we have a drawing that's drawn on a computer rather than a hand sketch. So we're just trying to understand what the ask is. So I think my colleagues have some questions, but I wanted to ask, so I think from the pictures we're seeing, there's an existing shed, looks
Yes.
like, and then there was something added on to that
Yes.
existing shed. And so is that building that was added onto the shed, is that in line? Is the back of it in
No.
line with the other?
I
structures?
give him the
No.
picture how it looks like
Okay.
in the back.
Is this the building you added on right there?
Yes.
Okay, that
that-
sure looks bigger than what I see on the.
Yeah, it does.
Are you sure that's the same building? It looks, and this one's got kind of a indentation, or it kind of abuts out. And I don't see any abutting part of the structure in this picture. This is what you built.
Yeah, the other picture that I give to you.
Okay, but where it says Lowe's and it's got the wrap, that's what you built.
Yeah, this is the back, yes.
Okay, all right. And then this is, okay, I'll let you look at those.
Because they told me to get the new building permit, and I already had a new build permit. I already have this.
I'm just looking at your photos here, and I'm wondering if, So this house wrap, the white, we call it house wrap?
Yes.
Okay, so was this part of the building already there, and was the siding just taken off and rewrapped? Like, is this the part that's the addition? We just don't understand.
Okay. We just tried to remodeling. But when we start to the remodeling, under all the, what is the concrete or is damage? Like, we need to like rebuild again because it's the only way. And that's why when the zoning code guy, he went to go and see the inspector, he said you need to get the new permit, but new building, not like extending shed, because he says new building.
So there was a shed there?
Yes.
And then you wanted to add to it, but then you had to take it down because of the damage?
Because on the bottom was really damaged.
And then you built on the same concrete pad?
Yes.
Okay.
For us, we would require a new building permit if you take it down to the slab. It's new
So
construction.
the
for us.
building that's in the picture does not exist now, but it's on the same concrete.
Yes, it's on the same concrete.
Okay, but that measurement that you have where it shows it's 5 inches, that's from the new build?
Yes, the 5 inches.
And the new build is closer to the fence than the existing structure that was rebuilt?
What we add to the shed is where it's close to the fence.
Closer to
It's
fence.
like 31 inches, but forget the 3 foot, we need 5 more inches.
And did you, we have two pictures here, right? The original, I'll call it
Yes.
a barn structure, and then a barn structure with this kind of detached shed.
Yes.
Did you remove those and build up new?
When we start to add the extended, when we start, like, everything was fine. But when we go to the old shed, we saw it was really damaged all the barrel. That's why we need to redo again. And that's why the inspector, when he saw, he said you need to get the new building permit. And we already have the new permit.
Okay, can we keep those pictures and make those part of the record, ma'am?
Yes.
You have extra copies, I'm assuming you can get copies of those somewhere else?
Yes.
Okay, we'll make those part of the record.
I have one more question, sorry.
Yeah, sure, if you'll stay up here, we've got some more questions.
It's noted here that the inspector discovered that this is a total new build, not
Yes.
just an addition.
Yes.
So what's new? Did only the concrete slab and everything's new?
No, the
beyond that?
concrete slab is fine. It's just all the material, all the wool was really damaged for the water. Like, we changed for the new one.
So new framing?
Yes, but this is not our thought. But when we start to,
No, I understand. I'm just trying to understand.
yes, that's why he told us to get the new permit. Because the old permit is just extended. Extended to the shed.
Where is the project right now? Is this what it looks like right now?
Yes. I have more picture on my other file.
Well, tell you what, we're gonna, unless anybody has any questions, we'll close the public hearing and discuss, and we might open it back up if we feel like we need to get more pictures from you. Okay, all right. Did you have another question? Okay. 5 inches is, it's not a big ask. I'm just real uncertain what's going on here. I'd almost would like to see a site plan. I think with a de minimis cost, Ms. Carpenter would know about cost better than I would, but it just seems like we could have a better visual here and maybe make a decision
I
I mean, unless you think there's just no possibility of there being a hardship, then I'm also trying to figure out what the hardship's gonna be, but I kind of try to get my mind around what's happening and where are the lines, and I get it in concept that they're 5 inches off the back property line, but I'm lost about, I could not follow what exactly what is there now compared to what's on the picture. I mean, I tried, but I'm not sure what's going on here, so, I mean, if there's,
go ahead, sorry.
yeah, there's no possibility of a hardship, then I don't want to trouble the applicant and have them spend more money in what's going to be a bad situation for them if this has to come down, but if there is a possibility, and I just really don't know what it would be, but it's hard for me to evaluate the potential hardship without seeing more of what's going on, but that's kind of where I am, so.
I'm in agreement with you. I don't have enough information really to understand, right? We're making the assumption that the fence line is on the property line. So it could be 5 inches based upon the applicant's information. It could be 3 feet, could be 2 feet.
Yeah.
So I don't know where the fence line, so that's kind of a starting point. And then, they were doing an addition, they're getting the building permit, but I don't know what, like you said, I'm confused on what exactly is being built. And you can see the previous structure did not extend beyond. So why did the new addition need to extend beyond? So without having the information necessary, and then like you said, you don't want to make them go through all this only to come back and be denied, but it's tough to know what the future's going to hold.
But you make a good point, which is if the fence is, if the boundary, the property line is outside of the fence, that they may pick up the 5 inches. I don't know.
Or it could be the other way.
It could be the other way too.
Right.
It could be that if they need another, they're
Exactly. It's not uncommon for those fences to be off by feet. Especially, previous to a lot of this stuff, people just put fences in generality of location. So I think getting some more information, a survey, it's called a detailed survey, shows everything kind of within 0.1 inches and getting a little better understanding of what the ask is would help us make a determination. Because right now, I don't have enough information to vote correctly, I guess, would be the best way to say it, but I don't. So I don't know if you want to defer to give the applicant some time to provide us some further information.
I will make a motion unless, it seems like we're pretty much in agreement.
I think my request is, I'm agreement what is discussed, but for us to determine is variance. So why this new structure is sticking out closer to the property line, and so applicant may need to come back to us to the reason for the hardship, why this structure was being closer to the property line, encroaching 3 feet setback, if that's the case. So I would like to have that information when they come back.
Yeah, I think that's smart to have that answer and also a survey showing where it actually is the fence. Because they may get the survey and be surprised. They may not be needed.
I'll make a motion that we defer with the direction to the applicant that to consider this further, we would need a site built, an as-built, I call it as-built survey.
Boundary line survey?
A boundary line survey. Would it also not need to show the as-built features of the?
Yeah, that should show the as-built. That's as opposed to showing topography and utilities. We don't need that. Just a simple boundary line survey.
A simple boundary line survey.
Showing the property line and showing the location of the structure on the site.
It would need to be, just for further clarification, a detailed one. A lot of them, will sometimes say plus or minus a foot. This needs to be detailed.
Okay, detailed, okay.
Yeah. Okay. So.
But no topo, no utilities?
No topo,
yeah.
no utilities, anything like that.
Yeah.
And Ms. Johnson wanted, I will make the motion, and then I'll remind her too what you wanted, if that's, so, unless you want me to put it in the motion. Okay, I can amend the motion.
No, that motion is fine.
All right, so the motion is made with the help of you two. A boundary survey that's considered a precise survey. Mm-hmm. Okay, so that's the motion. Is there a second? Okay, any discussion? All in favor? Okay. So what we're doing is deferring this. I guess we need to pick a time to when we defer it. I didn't do that. But does that need to be part of the motion? Or can we just,
I think you need to state what date it will be heard again.
okay, so I need to,
December
I
might be
need to
tough.
amend the motion to make a date. And so I don't, this time of year, it seems to me like it's going to be hard to get somebody out there probably. So maybe the second meeting in January would be,
I think there's only one meeting in January, right?
The
The 16th, I think.
Is that
Yeah.
right?
what's the date?
January 16th.
January 16th. So I'll amend the motion that we defer it until January 16th.
Second.
All in favor? Okay, so what we need to evaluate this is what I just talked about, which is a boundary survey that's considered precise. Mr. Ransom's concern is that if it's a survey that says more or less 6 inches, that's not going to work because your application may depend on inches, literally. So that's one thing we would need to consider this. I would also tell you that it wouldn't hurt to have some pictures too of what's built there. And then, Ms. Johnson, I'll let you tell her what
Yes.
else we need that you mentioned.
With this picture, it seems like a new structure, right here, sticking out, that make closer to the property line. And if there's a reason for that, and we should consider as a hardship, that would be helpful, why it has to stick out closer to the property line. But I'm thinking after the survey, it might be possible the structure is entirely within the property line and the applicant may have cleared. If that's the case, she doesn't have to come back, correct?
Right, that's right too, yeah. So I think what she would, I guess y'all would just. Does that make sense?
Okay, yes, because right now we are not working nothing there, because what the inspector require us is to have the new permit, like build the new building permit and the engineer's lab letter. We already have those, just we're waiting like this decision to start to working again.
Okay. All right, thank you.
Mr. Chairman, just an update. I called case 245 on Bryan Street. And was nice to point out to me, under our rules, that case will be dismissed due to lack of prosecution. Since the appellant did not come today, that case will be dismissed. They will be allowed to refile for a later hearing, but it'll be dismissed today because they failed to appear and prosecute their case. So case 245 is dismissed. And then, so our next case will be at the middle of page 4. 2024-249, Mr. Josh Bergener is the appellant owner of the property located at 2308 Woodmont Boulevard. He is requesting a variance in the side setback requirements in RS40. The appellant is seeking to construct an attached carport, porte-cochere on the existing residence referred to the board under section 1712-020A. I know the applicants are present. Are there any parties present opposed to case 249? Chairman, seeing none, gentlemen, you've watched a few of these from the back, so I'll go through the pictures first and then turn it over to you all. The subject property is located here on north margin of Woodmont Boulevard. And from the applicant site plan, this is the existing residence, and they're proposing some additional constructions, I think, in a couple places, but where the variance request is concentrated is located right here in this area. And the zoning code requires a 15-foot side yard setback, and they're proposing just a little bit shy of 5 feet. So I've got that listed there as a 5-foot variance, 10-foot variance requested along this side. And then this is a view looking into the site from Woodmont Boulevard's behind me. That addition construction will occur on this side of the property. And then views of the homes on the right-hand side and then the left-hand side, and then just a kind of a zoomed-in view location of that construction come off the side of the house here and down. And I will leave this photograph up. Gentlemen, if you would please state your names for the record and present your testimony to the board.
Good afternoon. My name is Josh Bergener, and I am the owner of 2308 Woodmont Boulevard, along with my wife, Lindsay Bergener.
My name is Chris Nunn, representing Strickland Architecture. My address is 612B East Borough Drive. And thank you all for hearing this case today. As Mr. Hargis said, we are applying for a side yard variance for an attached carport, requesting the side setback be reduced from 15 feet to 5 foot 1 inch. The house is a little bit askew to the property line, so it is just at that one column closer to the street that setback would be 5 foot 1. It's our assertion that this is a necessary solution to provide the client's desired functionality to be able to park adjacent to the house and come in from the car without being exposed to the elements. When we did site analysis, analyzing, putting it on the back created additional complexities and challenges in terms of how to make that attached carport work off the back because of the uses on the back of the house, living in bedroom facilities. So we're asking for side yard variance. We do have support from the owners of 2306, Joseph and Sally Bars. I believe there's an email in your packet that states their support.
Is that the red brick house that we're looking at on the right?
It is.
Okay, that's where the setback into which you'd be building, right?
Correct.
Okay.
I just did want to point out that as an encroachment goes, this being a covered carport would not be conditioned space, would not be occupiable space. And so our hope is that that is a fairly minimal encroachment that presents no further harm to that relationship to the adjacent property. I did also want to point out that there is precedent for this in the neighborhood. Just down the street at 2318 Woodmont, there is a very similar condition where there's an existing side yard attached carport to a house very similar to this one. Yeah, that's the extent of my remarks.
The frontage, this says 100-foot frontage on this lot, it looks like, from how does that compare to the neighboring properties? Are they all pretty much 100 feet, or is this one narrower?
No, they're all pretty much 100-foot lots. There are a couple of double lots further down.
A couple of what lots?
Double lots, but by and large, they're consistently this width.
There's from what I can tell, there's an existing detached garage in the rear and then a shed adjacent to it. Do you know what the setback is from the detached garage to the side setback? It's not called out here on the survey, or I can't.
I believe it's about 5 feet. I've got my laptop if you want me to look it up specifically. But I believe it's about 5 feet.
If I'm looking at page, I guess, Z0.0 in your packet, it looks more like 10 feet.
Okay.
So that's one question I have, and then the second question I have, what's your clearance in the porte cochere? It looks like 15 feet.
Yes.
Looks like you've got some steps, about 15 feet.
Yes. Yeah, I think the clear width between, sorry.
No, you go ahead.
The clear width between the planter and the interior of the columns is about 11 feet.
About 11 feet, okay. Did you find that? Oh, I thought.
No, go ahead.
I can go look it up if you'd like.
Yeah, do you mind?
I don't.
It would just help. Thank you. Joey, while he's looking that up, in theory, if a variance like this is approved and years down, decades later, someone comes and says, hey, I want to add an addition above this porte cochere, what is...
We would actually bring them back here for an addition to a non-conforming structure.
Okay, so they would have to come back here. Okay. personally, a porte-cochere is my favorite architectural feature, so I might have to recuse myself because of the, how much I love them.
Well, I was just glad you pronounced it. I wasn't going to try to
I
argue.
pronounce it incorrectly all the time.
Well, it sounded pretty good to me. It sounded like you got the French part just right.
Yeah. I mean, I think they should be like a front porch. I think they should be, you guys recently, you can have a front porch extend 6 feet beyond the, I think the building restriction line in the front, Joey. Is that officially codified yet? Yes. Yeah. I think something like that should apply for these as well. And only these, but anyways. Does anybody else have any other questions?
The information is, you're getting the height, is that right, Robert?
What's that, sorry?
You wanted the height, is that what he's getting for you?
The distance, there's a detached garage in the back.
Okay.
That's off the property line, and there's also a shed next to it. And I was
You
just,
want the distance to those?
the distance to that, from the looks, it's like it's 10 feet. I mean, he has the support of the adjoining neighbor, and it's an open-air carport, and if there was anything that would have to be done in the future, it'd have to come back here. So.
Thank you for your patience. Sorry.
No, it's all right.
Took a second to open the survey. So at the front corner of the garage, it is just under 9 feet from the property line. And at the rear, it is 8.5 feet. So it also is askew to the property line.
Okay.
Any more questions? And there is no
Thank you.
opposition,
Yeah.
correct? Okay. All right. Well, if there are no more questions, we'll close the public hearing and discuss. Well, I mean, it's a very attractive, I'm with Mr. Ransom, it's a very attractive architectural feature, but somebody's going to have to point me in the direction of a hardship, and I'm looking for one, and, there's some, it's really, I guess, not possible to put it in the back because there's already a covered patio, but I don't know if that really quite, I think we've been told before by our legal counsel that existing buildings aren't part of the characteristics of the property that you get to consider, but I could be wrong about that. Anyway, that's what if somebody can.
I'm same as chairman. I do think it's a great feature, and I love this porte-cochere. But I'm having a hard time to find hardship to determine why do we have to grant 10 feet closer to the site setback. If, the lot is shifted to one side, and then that's the only portion it can go, it's one argument, but it seems like just because they want it, it is the reason for us to grant the variance. So I'm having a little hard time coming up with finding the hardship as well.
Yeah, the house is askew on the lot, but.
I mean, I could even, consider if the existing garage is already closer to, encroaching within the 15 feet of side setback. But it seems like this rear garage has a 9 feet setback. If it's in line, yes, it's in line with existing garage, it's already encroaching, therefore the variance will be reasonable. But if we go to that argument, we are granting additional 4 feet of
Right.
variance.
And they have,
So,
as currently designed, it sounds like there's a planter next to the house that would, I guess, turn into steps, but that wouldn't work. They'd end up with like 6
Right.
feet.
I would be persuaded, yes, in line with the existing garage, it's already closer to the property line. It's already encroaching 15 feet side setback. Therefore, the request will be reasonable. But this one is asking additional encroachment. So if somebody has some clever argument, I might be persuaded. But otherwise, I'm kind of on the fence on that.
No, I think I would be in line if it essentially was generally in line with the other one. I just don't know if physically it would work, because there's an existing driveway that goes through there, which looks like that's what they're trying to match up with. You know, sometimes these things are a shame, because this would be a net positive for the house and the homeowners, but we have to stick within the bookends that we're given. I mean, the house is, you know, it looks like it's kind of equally on both ends.
Mr. Carpenter, do you see anything that would be a hardship?
It wouldn't allow it to go to the
I
left.
think we're
just the
all
grade.
looking hard for one.
The grade wouldn't allow it to go to the left, so it has to go to the right.
Just that the existing driveway's there. That's the only thing I see that they're trying to work around, the existing driveway feature of the land.
And can I open it back up for one question to the applicant?
No, I'm sure, no problem. Anybody object to that? No.
What was, you stated earlier, what was the reason you couldn't put it in the back? Kind of around what's noted as the concrete parking area in the back? There's a masonry wall, it looks like.
Yeah, there were a couple of reasons not to be able to put it on the back. One of which is the disparate uses on the back. So there's an entry right at the corner, but wrapping around the back of the house, there's a den and then a bathroom, laundry room, bathroom, and bedroom. So that was the decision. Basically, felt like it was not practical to put the attached porte-cochere off the back. Also, from a traffic flow standpoint, to be able to make that turning radius, it would have to be about halfway down this house in order to be able to make the corner and be able to back up and get back out of there. And so the flow was going to be quite challenging within the site if we put one off the back within the existing setbacks.
Just the ability to get a car.
Yeah.
Question, did you place these two in support columns at the edge of the current driveway that exists right now?
Yes.
So the driveway's not moving, and you
No.
place those there, okay. I'm a little confused on a couple of these renderings. I'm looking back to that down page where you've got, on the existing house, it looks like you have some steps and a planter.
Yes.
But if you look at this picture, I guess you can see some boxwoods in it, but then there's some other photos, and I get it. These are 3D renderings, very rough generalities, but some of these renderings don't show that planter. So is the plan to remove that?
The plan was to have just a short planter, just this side of the steps, and then the remainder of that would go away.
Okay.
The limiting factor was the relationship of the house to the property line and the amount of grade change from the finished floor down to the
Getting the
existing
steps
grade.
down and, exactly.
You had asked about whether the hardship could be related to a building or the terrain, and I just wanted to call your attention, in your materials, right, you have variance case law. There's a folder that says variance case law, and in that folder is a case called Cobble versus Greene County, which there's a discussion of that very issue, and it focuses on the terrain as being the hardship.
Right.
And there's language there to the effect, a desire to build a carport does not in itself generate grounds for a variance.
Yeah, I think you told us about that case many meetings ago. I appreciate that, yeah.
Could you repeat that? You said the desire to build a carport, I lost you.
Oh, a desire to build a carport does not in itself generate grounds for a variance, and it has to be something related to the terrain. That's sort of the gist of that case, in terms of hardship, that is.
Any more questions, Mr. Ransom?
No more questions for you, thank you.
Well, I would just tell the applicant, I think it's a very attractive feature, but we have a lane here and we have to find a hardship to grant a variance. I just can't, and you don't have any opposition, which is good, but I cannot get my arms around any hardship that exists with the topography or the characteristics of the land. And that means, in my mind, my hands are tied. So I'm going to make a motion that we deny the variance and for lack of a hardship.
Second.
There's a motion and a second. Any further discussion? All in favor? 4-0. Okay. Thank you for coming. Sorry.
Thank you for your time.
Okay, our next case is case 2024-250. Mr. James Fyman, the appellant, D.B. Todd Partnership LLC, owner of the property at 1818 Dr. D.B. Todd Jr. Boulevard, requesting a special exception from the adaptive residential requirements in CS. The applicant seeking to construct 2 single-family residences. All right, applicants present? Oh, there you are. Any opposition present to case 250?
There is no opposition?
No opposition? Okay. Mr. Fyman, you'll have 5 minutes. Let me present the case record. Members, you do have a recommendation from the Planning Commission for disapproval. Mr. Fyman, if you've not seen that, I'll get you a copy. Let me see. Wait, planning told you they recommended approval? Okay, I'll get you a copy of.
Anna went to a community meeting and had one person show up. They were in approval.
Okay, I'll get that to you here. The subject property is located on the east side of Dr. D.B. Todd Jr. Boulevard. It is the parcel you see in red. It is zone CS. This is a case. I'd say this is one of 3 cases on today's agenda that deal with adaptive residential use. Those 3 cases fall under the old rules, really have no effect on, not like Neely's been where the zoning changed. Nothing's different here. We just look, when permitting comes for him, we're going to look at a different set of rules versus the current rules in the book. But all permit multifamily uses. In this instance, multifamily use is required, so 3 or more units. Mr. Fyman's wanting to build just 2, so that's what's coming before you by special exception. Again, on the east side of D.B. Todd, am I north of Buchanan Street? Yes, okay. I cropped my map to make it fit on here, so I cut that off. But you see it's CS, and again, the appeal is to allow 2 single-family residences. This is the subject property on my visit on the 13th. I did not get out of the car. It was pouring down raining when I shot this photograph. I mean, like monsoon. So that is our lot. On the east and west side, obviously on the building to the right is abandoned. And then this building, I think, appears to be abandoned as well. And then directly across the street is a tire shop. That's been there for many, many years. But Mr. Fyman's request is to build 2 single-family residences on that lot, which you see there. And the Planning Commission, I'll pull up there. Again, to the members, that recommendation, obviously, accepted on face value. It is not binding upon you, but you do need to take into consideration their recommendation on these cases. And for Mr. Fyman's benefit, I'm going to put that on the main screen so we can. Slide that over there. Go. And the analysis section is at the page there. And I'll leave that on screen for you, Mr. Fyman, so you can read why the board may have, but during your testimony or if the board has questions for you.
And I read it to the applicant, just to summarize, basically, they say that even though you're putting two houses on a 50-foot frontage lot, it's not high enough density to support the urban mixed-use corridor policy, which envisions higher density. I don't know if there's any definition of, to me, what is higher density. I mean, to me, you got a 50-foot frontage lot with two homes. That's I kind of scratched my head on this one when I read and I think if they would have defined what they consider higher density or showed me where it's defined. But anyway, that's jumping ahead to my summary of what you haven't read. So, but you have 5 minutes. If you'll state your name, if you'll turn your mic on first, please, sir. It's a button on the surface there, and you'll see it turn red. And if you'll say your name and address.
Okay, so my name is James Feinman. I live at 1728 14th Avenue North currently. I've lived there for about 5 years now. I've built several homes in the neighborhood, and I've revitalized several houses in the neighborhood. I'm very well established in the neighborhood. I think just about every home I've built over there I've kept except for two. And so I have a couple of rentals over there, and I live in the community, so I'm very well established. DBR Todd and Buchanan is a semi-rough corner still. However, it's being revitalized. There's some new restaurants and there's like a pet restaurant, and there's quite a bit of stuff kind of coming in the area. Down Buchanan, there's a lot of stuff revitalized. And then on DBR Todd, it's kind of moving down that way, so that's good. What I would try to do is just kind of build within the character of what's coming down that street, which is kind of like taller, single-family type residences. As far as density goes, the reason why I'm trying to reduce the density is because, as you noted, it's a 50-foot by 130-foot lot. It's got a 20-foot setback. The front has, I don't know quite the setback there, but I'm kind of limited on how much space I have. It is CN zoning, so I could build all the way to the lot line. However, again, I don't think that's advantageous to the area, so I'm kind of limited with my building footprint. So I thought that the two single-family homes would fit in that area to kind of be in line with what, you know, if you look down Buchanan, for instance, there's a lot of kind of like townhome-esque kind of properties that are dotted down the street right there, and they look really nice, and the area's definitely improved due to them. So that's kind of what I'm going for.
Did you talk with anybody at planning about this?
That's the first I've heard of it.
Okay.
In fact, before I did my last mailer, which was for my community meeting, she looked at me and said, I don't see any opposition. The lady who does the mailers and emails me with all the stuff for the next step, she says, I don't see any opposition as of now, because that was when I was talking about my mailer. And then I went to my community meeting, and the only gentleman that showed up was a super nice guy that we've actually been in touch with now. He was like, so wait a minute, you're reducing density? And I said, yeah. He says, I ain't never seen nobody do that in my life. And I kind of just figured I didn't think it would be a problem. So, and I would take my access from the main road there, and I would put my parking kind of in the front. But I don't think there'd be any problem with accessing it either. So I just don't, I don't see how this could hurt the community or look out of place, either one.
Any questions for the applicant? Okay, thank you. We'll close the public hearing and discuss. So it's a special exception, and basically planning has said that all the requirements are met. I do think it's a head scratcher to me that they conclude it by saying, well, it doesn't meet the mixed use corridor policy because apparently it's not high enough density, but it is two residences. I mean, it's not a great site plan, but if it's a 50-foot frontage and 130 feet sideline, I guess you could get more residential usage out of it, but I mean, you got to provide for parking too. It's an arterial street. It doesn't look like there's any. So I was kind of surprised that they considered it not high enough density.
Yep, I can talk to why planning recommended come with this, because it's a commercial T4CM. That means a commercial mixed-use corridor. So that means that this base zoning is commercial CS. So it will be like a first floor commercial, usage. and then upper floor, it can go residential. So that would be kind of losing opportunity, I think, planning standpoint. So I think that's where their recommendation is coming from. Because yes, single family unit might be easier and quicker, but next door is a business. So there's like a future opportunity is kind of missing. And if we were to allow just 2 single family, all future building might follow that, lead. So high density, because it's a arterial boulevard and, 2 lane, I think it's like a 4 lane, and including turn lane, it would be 5 lane. So that would be like a high capacity road. So it can be, access can be from the rear, from alley if there is. So with that, long range planning, and I think it would be kind of missing great opportunity to turn into like a future mixed corridor usage. I think that's where the planning is coming from. That not mean I'm 100% agree with it. Of course, those plan and actual reality is not sometimes happen at the same time. So I think that's the planning perspective. So I'm kind of
It's zoned commercial, right? So the only thing you can build now, if you can't go adoptive residential, then you're stuck with commercial. And so you're saying what planning wants is probably a mixed commercial residential use there, is that?
Or it can be higher density multifamily residential unit.
More than 2?
Yeah, more than 2. It
So-
can be, 8, 16, 20. It can be, because it will be built to, lot line. So it can be higher, 4-story, 5-story.
Right.
It can be, yeah.
And I guess, what I'm struggling with is, what do you do with the parking? I guess if you go up, you build the parking below, but that looks pretty inconsistent with what's going on over there. That's what is it better off right now that it remain commercial, or if nobody's willing to do that, is it better that somebody's willing to put 2 residences over there? So did you follow that? That's.
Yeah, I do understand that argument, because intent of the planning and actual gradually happening, because some empty lot will be, somebody want to build on it. So would that be better for us to deny and wait for, future higher density? Or would that be better for our body to, yes, it may not be as higher as the plan calls for, but it will create some residential unit and therefore meet the policy. I think it's up to us to interpret intent and, if it's meet the policy or not.
I appreciate that. Thank you.
I forgot, was the public hearing open or closed?
It's closed. Okay. We can reopen it if you need to.
No, I just forgot where we were in the process. And I guess I'm hampered because I don't have that zoning code in front of me of what the section that should be looking at. I'm just wondering, what does the zoning code say? I guess I'm getting from this is that they're not allowed to build 1 and 2 family residences.
I'm reading it as just commercial services. I'm assuming that means there's no residential. I could be wrong about that. But.
Yeah, and that's allowed with the adaptive residential provision, which is allowed by a special exception, and all that this is all new to me.
Right. The adoptive residential allows you to use commercially zoned property to adopt it for residential use if you meet the requirements of the special exception. That's the way I understand it.
And I don't have it in front of me to study.
The other thing that, they want for the density is, the density supports the businesses in the area, but the density also supports infrastructure improvements as well. They noted it here, but the ability to get, new infrastructure in the area and everything. So that's another reason why they want the density. If you put 10 units here versus 2, you're capturing a lot more tax value on those main streets. Yeah. So, and they mentioned it here too, but that's how you can get public services and buses and all those other things.
But It's not a hardship case, so he doesn't have to prove a hardship like the lot is small or something like that. But this does seem like a very small lot, and it does seem like he's limited in what he can do with that lot. And that's the part I'm struggling, because having designed on small lots, you can't fit everything on it that the planning department desires for a certain area. I know that from experience, so.
Can you go lot line to lot line on this one?
I think so, yeah.
Can I open it up for two questions?
Sure, and I have no objection. I don't know if anybody else does.
Could you go lot line to lot line on this one for a higher density use? I believe you can.
You could, the building on the right, which is it's like a burned down red brick building there, is encroaching slightly on my lot. And I don't know, and this is where I guess I don't know. I mean, I build buildings downtown that are connected, but typically, like if you go residential, you'd have to stay so many feet away from the one beside it for fire code. Number two, I'll be honest with you, I've never built anything commercial that is on the side of another building. So I can't speak to how I would build to the side of that building. It's a red burned down brick building. I just don't know. Honestly, I don't have the knowledge to answer the question as if I could build against that building. But the fact that it encroached, if you notice, I mean, the site plan, I didn't want to draw up full plans until I know what the verdict is here. So I apologize, I don't have anything full for you to look at. But if you notice, I kind of skewed the buildings. One's over to the one side and one's over to the other side. So I tried to, where the encroachment is, I tried to kind of pull off of the building there and then go back towards it on the other side so that at least the buildings weren't just, keep them a little bit aside. And then I think to speak to the density problem, I just don't really have interesting. Oh, that was what Paul drew. Okay, I'm sorry. Paul helped me out with this thing. I looked at that and said, I turned in it was with my mailer. I can send it to you guys. It's the way I have it drawn is the two buildings would be basically 32 wide by 22 deep. One would be pushed to the rear setback, and then that one would be closer to the red building. So kind of where you see the 1818B in the back, that one would be to the right, and then I have 10 feet in between them, or I could possibly do a little better than that. And then the other building is rectangular again, 32 wide, 22 deep, pushed to the other side, away from where my encroachment is. And then I'll have somewhere between 55 and 75 feet of frontage to where I can have parking. And so if the board turns this down, which is fine, I accept what the verdict is today, then my next step is how do I build something that's commercial, because the lot is limited, with good access and good parking. I'm sure I've figured a lot of things out in my life and I can do it, but the lot is definitely limited.
Let me ask a question. Is there an alley behind this
That
property?
was my second question.
There is.
Okay.
There is, and it is not terrible. If I go with residential, I guess my concern there is, and this is something that's, you can call it a hardship or not, but I don't know if any of you guys have had the pleasure of going to the corner of DBR Todd and Buchanan, but they just closed down there was like a liquor store, convenience store in the corner there that has been a problem. I've been working in there since 2014, and it's never been safe.
We've heard.
And so they closed it down by court order and whatnot, but a lot of the people that were hanging out in the corner there are now pushed over, and they sit literally in that alleyway. And so my dad just moved here, for instance, and I drove down that alleyway, and the first time we drove down it, we almost didn't get through there. And I'm big on community. Like, I love my community. I don't want to move for any other reason than my son's school. I love my community, but I know where to go in there. And I don't feel like if I put residential units in there and have them accessing from the back, that it's going to be safe. So I'm just putting that out there. They can access from the other side, and the alleyway is actually not bad. Some of the alleyways in there are tight. Some of them have trees all growing through them and everything. So, if you access it from the other, I want to say it's clay on the north side, then it's not that bad. The south side is definitely dangerous.
I have a question for the zoning administrator. Was there any more questions? Do we need to close the public hearing again?
It can be closed.
I want to ask one quick question to the applicant. Sure. So with this drawing, I know if you are in the drawing phase, so I don't think you have had a chance to talk with NDOT about the driveway access. Do you have any input from NDOT about that?
It has to be 15 to 22 foot wide, I believe, curb cut. And Joey may be able to answer actually the code for it, but NDOT would have to ultimately approve it. But I think it has to be 15 to 22 feet. So I figured 15 to 17 feet of actual turnage so that I've got plenty wide where I'm not making somebody have to stop on the road and then turn. So I'll make it, I mean, I'll probably, when I start building, turn on that thing, you know, I'll design it, but I want to make sure that I can make that access without impeding traffic. But I can go up to 22 feet wide. I believe that's what and we've done this a couple of times, so I believe that's what it was.
Is the public hearing closed?
Yeah, we'll close it now.
So my question is, does this part of the zoning code require commercial with the residential? If the adaptive residential provision is used, do you have to have commercial with it? Right.
In this version that applies to Mr. Fine's case, yes. The zoning code says 1 and 2 family structures may only be, I was just looking at it and I closed my page, sorry. I still have the version that applies to Mr. Fine's case, but it has been amended by the council. But the one that's applicable to him is 1716-030, and it says, if I can get to it. It's item 2B in that version, but it says single and 2 family uses shall be permitted only in an existing building or as part of a new mixed-use development within a single structure. And that particular section, how it was written, and it lists through that, like I said, that's number 2B. There was numbers 1 through 10, and 11 says where the proposed development cannot satisfy the standards of this section, the applicant shall submit for review of the Board of Zoning Appeals a special exception. In granting such an approval of a special exception, the board shall determine that the applicant has demonstrated that the relief being requested is not injurious to surrounding properties nor violates adopted general plan. The board shall not act on any application without considering a recommendation from the Planning Commission. And it's since been rewritten. I'll just stop there because the new code has no effect on this case.
So
it's different now.
We're permitted to allow, even if he doesn't have any commercial.
Correct.
Permitted to allow
Correct.
it. It's not injurious.
That's right. It's been amended. You won't be seeing any more of these cases going forward. Because the way it's been amended, you don't have this option to come here on the single family. You're not going to see any more of these cases like Paul and Mr. Feynman's cases.
Let's go back to earlier, Joey. What was the reason we wouldn't see it?
The councils wrote the ordinance in such a way that it's only permitted in a single structure, and then how it's located in here, it doesn't give you authority to deviate from that provision like this does. This particular thing, it says, the design standards are listed 1 through 11, or 1 through 10, and then 11 says, hey, if you don't meet 1 through 10, you can go to the board. The new one is written where the single family is outside the standards. I mean, it's like a prerequisite to even do it. And then design standards have to do more with architectural or setbacks. It doesn't have anything to do with use at all. So kind of how they've structured it, they've taken it away from you. And then I've got another zoning code section that says you can't grant variances inside an adaptive residential development. So it was just they've corrected kind of a loophole that they created to allow this ask.
So to kind of, I'll put out there where I am on this so we can kind of get, I think that I get what planning's saying, and I appreciate your explanation of why they're doing it because I didn't quite get that. But in my view, that's idealistic, and it's good to have idealistic standards. But practically speaking, looking at how this property looks right now, what's surrounding it, I mean, if this seems to be a much better use, it does seem to have more density than a single family home. And I don't, if this applicant's not allowed to build this, what will get built there? Will it be an overgrown lot for the next 5 years? So I understand and now with Ms. Johnson's help, understand what why they came out this way, the planning commission, but I think I'm okay with the special exception. I think it's we have the authority to do it, and in my view, it's a positive for the neighborhood and deserving of a special exception.
Not to stop your momentum, and I don't disagree with any of that. I guess one point of clarification is from NDOT, whether it opens onto this arterial street or goes into the alley. I'm not exactly clear from the letter that's provided. Maybe someone, it says NDOT takes no exception, but I'm unclear what it takes no exception to. And then it says, this does not imply approval of the submitted site plan as access and design will be addressed and coordinated during the permitted. So if I'm,
it's kind of their boilerplate language to say, on its face, we don't have any issues with the proposal, but if there are issues that arise, we'll deal with them on the permit side, as far as access and getting into it. And they do that so that they can look at it site by site rather than just taking a blanket stance.
yeah, I just know that, the intent of the alley is to push all the cars that way so they're not coming out on the street. So.
Right. And many of these,
The applicant might end up in a situation where they're saying, oh, 2 residential uses, out the back you go.
like Gallatin Pike, there's multiple curb cuts along Gallatin Road and you do have alleys serving those.
Yeah.
NDOT's goal is to get rid of as many of those ramps as they can. So it's kind of
cuts.
the boilerplate language to say,
No, I know. I guess I just,
we leave it to them. Zoning code allows every lot to have a ramp cut, but NDOT can always override us if, from a public safety standpoint, it's just not feasible to do one.
right. Thank you. And then, to add to what Ross says, this lot is small and fits, it's generally the same size as many lots, behind in the adjacent community that have 2 units on them. So, idealistically, yeah, it'd be great if tomorrow apartment complexes and everything sprouted up to provide additional density, but this goes from 0 units to 2. So that's a step in the right direction. So I don't know if anybody else has anything else to add.
I think I thought it was 5 lane, but it's only 3 lane, including the turning lane. So even though, arterial boulevard is a 3 lane, it's not like a high speed range. So I think, considering, I was worried if NDOT will insist, access from the alley only. But considering it's a arterial boulevard 3 lane, so curb cut may be acceptable.
I will say, and Ms. Karpenick is, I think, espoused this to you before, I understand the applicant not wanting to spend a lot of money on a site plan until he gets approval. I guess, sometimes I like to see something a little bit more definitive in terms of a site plan before we grant a special exception. He's asking for 2 units. I don't know how much you could really change that. There's not a lot of room to work with if you're going to put in 2 units. So I know.
Sorry.
No, go ahead.
What are the parameters within? So the special exceptions to do 2 units as opposed to
2 single-family units.
2 single-family units as opposed to 3 or more, right? That's the special exception. So if we grant the special exception for 2 units, what are the bookends that those 2 units have to fall within as far as setback lines?
We're going to follow the zoning code. So it'd be just standard zoning code setbacks for CN. You'll have 15-foot front, no sides, and 20-foot rear.
And what's that for height?
Height in CN, be looking at 20.
You want to see it? What do you want to show us?
I drew the call was my associate, and he submitted this thing to get it moving prior to me really looking hard at it. We've done
Yeah,
Can we, do we need to open this back up, or is it?
Yeah, we can open up, sure, nobody objects.
Okay.
Height,
What, has NDOT reviewed that? I guess they
BZA
have to review that.
at Nashville.
Well, and I guess it's a little bit different from, I mean, a lot of times we want the site plan because they're requesting a variance and they're not gonna be complying with the code, and so we wanna see what's this gonna look like when you build inside the line, so I guess that kind of,
Back to your question, the prior case on Neely's Bend was limited to 20, it was a 20-foot ceiling. CS is 35-foot minimum, and then 1.5 to 1 slope. So for every, remember, my side setback's at 0, so if I come in, 3 feet, I could go up 4.5 in height. So it's kind of a pyramid, coming in from front, rear, and the sides.
Got it. And, if they're building on the property line, I'm assuming that,
He'd be at 35 feet at that location.
yeah, would that, since it's a commercial district and it's a residential house, there usually are fire codes that you have to follow until you get X amount of feet off that property line.
Yeah, generally, you've got 3-foot setbacks for them without openings, glass, or anything on the property line. So for us, if you sat at 3, you could be 37.5 feet.
Right. If you're 3 feet, then you can have openings, right? Yeah, so that makes sense. Which is what you want.
I think though, the only thing before us is just, can there be 2 on this property and
yeah,
not 3 or more?
correct, yeah,
Right,
2
so
things.
if-
Yeah, I was out.
That is the style of actually both cases. This one and
Yeah.
the next are kind of identical in that respect.
Yeah, that was just kind of an all thing. If it's gonna be governed by the zoning code, and our question is just, can they put 2 residential units on this lot? I don't really think I've got to see a site plan to make sure.
Yeah, like you said earlier, it's a different type of case.
Right,
Yeah, I
it's
agree.
not about it's not about they're doing something outside the zoning code that we would want to.
It's not like those other height special exceptions that you run into where we know it's tall. How too tall is it? You want to know how much is out of compliance.
That's a good point.
Mr. Fineman's not asked for, in any of the discussions, not to be out of compliance. Like, we'll comply with the code, can we do 2 or not do 2?
Yeah.
Is kind of the.
I'm not concerned about the design because considering this is a T4, higher urban area, and then current usage is all over the map, having some commercial tire place, and so anything, any new building will be improvement and addition to that area. So if it's a modern, that would be fine too, and if it's traditional, that would be fine too, because it's urban area, so I think any design will kind of, in a way, strangely fit into that interesting mixed-use corridor.
Well, with that, I'll make a motion, we approve it, take special exception. Motion and a second, any further discussion? All in favor? Okay, that passes. Yep, you're welcome.
All right. The penultimate case is case 2024-251, Abram Mitchell and Cheryl Miller and Michael Terry, owners of the property at 107 Old Trinity Lane, requesting a special exception from the adaptive residential requirements. And it's got listed in here along with a front setback. I was just going to look at the case real quick because in my preparation of this PowerPoint, I will remove the street setback from it. While they're talking, I'll look as to why I took that out. I didn't think it was needed any longer.
Are you talking about the last case?
No, 251 at the top of page 5.
Okay, the one we're on now.
Yes, sir.
Okay.
Yeah, it was adaptive residential to be allowed to do 2 units instead of 3 or more. But we have on here a street setback variance. I don't believe that's required. But let me go through this is their site plan they submitted to us. It shows, 2 residences, these rectangles here and here, sitting approximately 30 feet off the front right-of-way line, complying with the side and rear setbacks. This is also a CS lot here. And you see on the left and right-hand sides are other existing single-family residences that are here. If you give me 1 second, I'll pull up the parcel viewer map. But while I'm doing that, if you folks will go ahead and identify yourselves for the board, and I'll come right back and show them.
There is opposition.
Okay, and there's opposition present as well. All right, sir, ma'am, go ahead and state your names for the record.
And can you give us your address, please, ma'am?
this place, or my
Your
address?
residential address.
Okay, 1614 14th Ave North, Nashville.
Okay, thank you.
Abram Mitchell, 640 Spence Lane, Nashville, Tennessee.
Thank you.
Yep. I did withdraw the street setback variance, and I'll show you members as to why in that case. These are the two lots that are, so the subject lots here in red, the houses that you saw on the drawing, the house on the left is in an RS5 zone district, and the house on the right-hand side was also CS. And if you'll note the depth of this lot, the zoning code in this particular case being CS, their setback is only 15 feet in CS and not 30. I think my examiner, when they did the application, because it's a single family residences on this lot, they were treating them as a contextual setback of having to match these other homes to the west, and they are not required to do so. They just have to meet the street setback, which is 15 feet in CS, and as you saw in the site plan, they're showing me 30. So I did withdraw the street setback. So in front of you is whether they can build 2 residences or have to build 3 or more. And again, just looking at the subject property, on my right-hand side of the photograph is another CS zone property. The house with the red car, and over to the left is zone RS5. And again, these homes are in the single-family zones here. And these 2 homes are in commercial zone CS.
Can I ask you a quick one? What's the setback on the sides?
On the sides in CS, there is no setback. Now, in this particular location, there will be some distance required here of 5 feet, and that's in order to provide landscaping and a privacy fence along this property line here. Yes, ma'am. But normally, if this were also zone commercial, like it is over here, there's not a minimum setback along that line. But in this instance, a 5-foot setback is required. So they're going to have to do some landscaping and a privacy fence along this property line here. Okay, we do have opposition present. Each side will have 10 minutes to present, and if you guys go ahead and put on your case on why the board should grant it, and then we'll hear from the opposition after that.
So originally with this lot, we were wanting to do a quadplex here, but looking around at the neighboring properties, it doesn't seem to conform. We could do it, but we wanted to instead request to be able to downzone the property to build 2 so that it more so blends in with what the neighborhood is looking for. And our hardship would be there's a sewer easement on the property that would make it a little difficult to build the quadplex, but it does work with 2 units.
And just to add on that, the variance for the street setback?
You don't have to worry about
Okay, cool. I just feared they would take the contextual, but we're good on that. Okay, cool.
You don't need a variance.
Okay.
So one of the requirements is that it has to be, under the adopted residential standard, it has to be oriented towards the arterial street. And planning says it's not, and it doesn't look like it is. And that, what's that? I'm looking at planning's report.
Yeah, they said that arterial street was in the arterial street.
I'm assuming Old Trinity Lane is not, because they say it's not oriented towards it, so.
So I was under the impression that that's when you were trying to have Airbnb eligibility.
They say the adoptive residential standards require the building entrances to be oriented towards the arterial street. The proposal does not meet the first requirement due to the entrance fronting on a local street.
Okay. So
do
then they
they
making
front on the
a
local
change to
street?
that rule, maybe a few months ago where they changed it to where it didn't matter whether it was on the arterial street or not.
Well, they made this report November 4th, so, about 4 weeks ago, and to me, it looks like
I was in here last time for another property, but I'm pretty sure within the last 90 days or so, because I know what you're talking about as far as the arterial street, they made it to where it doesn't matter whether it's an arterial street or not. You can have adaptive residential eligibility with a CS lot.
Well, as of November 4th, they disagree with that. They say the adoptive residential standards require the building entrance to be oriented towards the arterial street. I'll ask, is that changed?
I have an email from planning that says that it is adaptive residential.
Yeah, this particular case falls under the new,
Okay, so it's not, they're wrong, it has changed. All right.
yeah.
Isn't the stripes?
Ma'am, if you can wait, please, we're going to give you a chance to talk. That way we maintain protocol here.
This does fall under the new residential development standards under Council Bill 187.
Do you know why planning would have put this in there? I mean, just trying to figure out
What is Old Trinity? That's not an arterial street.
It's not.
No.
So how would you face this towards an arterial?
Well, what I'm hearing is that even though planning says that's a requirement of the adoptive residential standard, it's really not, is what I'm hearing, is from Mr. Hargis.
Right, but this lot also seems to be kind of
But
buried a little bit in a residential.
the new law they just adopted does not specify arterial street. It says building orientation in any new or existing building, a primary building entrance shall be oriented to the street. So it does not say arterial. Just the street.
It does not.
So yeah, that's what I was saying they changed in the new rule.
They did, yeah.
Last quarter.
Number 4, the building orientation. Primary building entrance shall be oriented to the street. On a corner lot, entrances shall be oriented toward each street. The first version of that bill, this was a little confusing for folks that don't see us every day, but when it was originally adopted, when you look on the website, this language that you see here, all of this text, was the first draft, if you will. And then the council submitted a substitute ordinance, which is this link right here. So this is the bill that was adopted by council along with those 2 amendments that were up there. And I think it did say that in the original version. But this one says, in any new or existing building, the primary entrance shall be oriented to the street. Meaning I couldn't do a development of like 6 units facing a courtyard, with a private drive in there. I couldn't have that sort of thing. These front units would have to face a public street. But I think that first version, and then the amendments to them had to do with whether you could do short-term rental, and this one had to do with PUDs.
Well, I mean, the bottom line is that's just not, what planning said about that's just not correct. There's not a condition that they're not meeting that has to do with them facing an arterial street, so.
Yeah, I do not see that.
However it happened, as long as I understand that's not a requirement, then it's not a requirement, so.
And as I talked about before, this is, this is sort of the last case under this. We've since made a determination that you can't ask for this under the new code for 1 and 2 family. This gentleman had filed his previously, so we went ahead and honored his filing. But the rules subject to him are these here.
Okay, y'all still have 9 minutes left, so you don't have to use it all, but you have it if you want it. And you can save some for rebuttal because you've got some opposition here too. So.
Yeah, I'm not sure what exactly is being opposed. But yeah, just to piggyback over what my partner was saying is, if you ride up and down this street, it is a normal residential neighborhood. With the current zoning, we could build multifamily, which, I mean, it would be a disturbance to the neighborhood. And then on top of that, what makes our case a little different than the other cases is I feel that we do have a true hardship with the sewer line being present on the lot. We have a 10-foot easement around that sewer line, so that further restricts, high-density building, which I would love to do high density, but again, it needs to make sense also. This is an investment, so yeah, I think, if we put 2 homes here, single family, it'll be nice for the neighborhood, it'll be nice for the area, and overall improve the community.
Okay, does anybody have any questions for the, okay, you have 9 minutes left for
We could save it.
rebuttal, so
That's
we'll
it.
hear from,
Yeah.
we'll hear from the opposition and then.
We confirm that the variance is not needed for the setback, right?
Yeah,
Okay, cool.
the street setback is, you're permitted where you're showing.
So we could, again, if we were to be approved for this, we could do a 15-foot setback.
Yes.
Okay. Thank y'all.
Okay, miss, if you want to come forward. Are there any other parties present? All right, I'll make sure.
Thank you.
And members, I'll just get one of your copies after this case ends to put in the file. Oh, wait, you got one? Okay, good. Yes, ma'am, no problem.
Can you hear me? Okay.
And if you'll state your name and address, ma'am.
My name's Pam Lane. I'm at 109 Old Trinity Lane. I'm the property to the left of what's proposed. You'll have to ignore some of this because I was the variance, since they dropped the variance. We saw that there was an exemption asked for a variance, so. But I represent the houses on the right of the property. I'm on the left of the property and the house on my left. I'll just make this quick. My name's Pam. I'm the owner of 109. It's been my residence since I was 8 years old, and I've owned the property for 30 years. The lot in question has been vacant for over 30 years. We've mowed that grass every summer, tended to that property. We've only talked to the owner one time in all those years. We did this not for the owner, but for our neighborhood. Now they have decided to build on the lot, which I think is great. One house, great, because it matches everything else there. As you can see, hold on, where did I go? Now that they've decided to build on the lot, which I think is great, 2 homes to build is just, it would change our streetscape. It would cause a major danger for us pulling out, but that was on the variance. So if they're back, I should be able to pull out. Right there, building 2 homes right there is the parking. What will happen is, if you look in my photos, people whip off of Dickerson Road. This is a little dead-end street. It's not Trinity Lane, it's Old Trinity Lane. We're a little dead-end street. We have all single-family residence homes on the street. All of them are set back. You can see the dynamic in my photographs. But people like to whip off of Dickerson Road really fast right there. And it's already a little bit dangerous where we live at just to pull out. But I think if they put 2 residents there, that what will happen is the cars will start parking on the street. And I think that's a huge security, safety thing right there, so close to Dickerson Road. And I understand that there are commercial. I think it's weird that they're zone commercial, but some of the other stuff is not zone commercial. But like I said, we already have several new builds on our street, which are wonderful, but they was single-family homes set back on one lot. They matched the streetscape of our street. And I've heard it said here several times, tall and skinnies, and that's what basically we're talking about. Let's see. I don't believe that they could approve hardship on that variance, but since they're commercial, they don't have to. We welcome progress. but it's just about trying to overbuild. And, I understand he said it's investment, he's trying to make money. But while they cash their check and move on down the road, and we've got this big, tall 2 houses, it'd be different if that was all over the neighborhood. I mean, I'm from East Nashville. I see it all over the neighborhood. But our neighborhood isn't like that. Like I said, we've all lived there and owned the homes for a very long time. And I mean, just look at my pictures from the top of the street down. I don't know how many floors. How many floors is this supposed to be? How high is these structures? 2-story.
We'll get clarification from the applicant in the rebuttal.
Okay. But, so yes, we have no problem with someone building. That's a tiny lot. It's only 60 feet by 90 something feet. So it's a small lot, but there's 2 other homes on the same size lots up there, and they're single family residents. So, like I said, we're all for somebody building there. The lot's been vacant since I was a child. So, but just not 2 big, huge houses on that tiny little lot. There's going to be a parking problem all over East Nashville right now. You can't drive down the streets that you once could because everybody's parking on the streets. Now, I don't know how many bedrooms these houses have, but, anybody that visits these people will be parking on the street. And that is a very bad street to be parking on. Little kids walk up and down from the bus stop. We're a dead-end street. So it's, you come up and go down. So therein lies my thing. I don't have any lawyers, or I'm a little nervous, don't have any lawyers or council people over here, but I have talked to the neighbors and they feel the same way that I do. And, we welcome 1 residence there on that tiny little lot, but not 2 large residents.
Well, it's good you came and brought the photos of the street. It helps give the context of what the neighborhood is like. And to be honest, they're actually asking for less density than what the planning department recommends. They recommend, per the policy, a 12-story mixed-use development on this property. So I wanted you to understand that they're actually asking for less than what the planning department is recommending. I have to say that again, 12-story mixed use is just not appropriate here. So I just wanted to point that out, and I don't know, it just seems like the right to come to the BZA and appeal these things is being taken away, and if it was going to be required that a 12-story mixed-use development be on this property, this seems really a shame that there isn't some kind of relief for that. Because this is not, as we can see in the photos, not appropriate.
Right. And also, I think that shouldn't it be taken in consideration the way the neighborhood is right now? I mean, if there was 4 houses down, there was 2 tall skinnies here and 3 tall skinnies, but we haven't had that happen yet. We still have a neighborhood there. And, if you were living next door and, like I said, we welcome 1 home, but I just think that 2 houses on that tiny lot, if they had a bigger lot, 2 houses on that tiny little lot there's going to be parking issues. Not to mention that lot drains down into my yard. It's not a problem because now it's all grass and it has to be a really hard storm, but there will be water storm issues if they build on there. And like I said, I do not oppose 1 house there, but I just think that, I think it's, I understand they're wanting to make money and flip houses all over, but, I wish that you would consider my standpoint and my neighbor's standpoint of how we feel about this. I'm sure y'all hear this every day, but I appreciate it. Thank you.
Thank you. Okay, applicants, you've got 9 minutes left.
And Joey, while they're coming up, I know the variance for the front setbacks out the door because of the zoning. What was the front setback by 15 feet, you said?
15 is required in CS zoning. The applicant was showing
They were asking for
30 feet. Yes,
30 feet.
Yep.
Yes.
We actually agree, with things like that. So we wouldn't try to push it up to 15 feet to, cause issues with the homes that are down the street. I understand, why you have contextual setbacks in neighborhoods. So I agree with that. As far as the homes, we're not looking to build 3-story. They're going to be 2-story. So I'll imagine these homes will be probably in between 25 to 30 feet max. As far as the bedroom count, I think we're at 3. I think we're doing 3 bedrooms. So it's not a large, it's not a large home. I think we're doing like 1,500 square feet or so.
What about the parking? Because you submitted us only the, envelope, the building envelope, so we have no idea where you are going to have garage or a parking situation. Do you have any thoughts on that?
Yeah, so again, I do plan to work with my architect to get the best design. I could show you an example of what we would do here, which is ideal to address the parking, like a 1-car garage in the front, accompanied by, outside parking pads. It'll be 1 curb cut shared between both houses. So you won't have to have multiple curb cuts and multiple people turning into different access points. It'll just be 1 access point, which in my opinion would make it, less hectic in and out of that location. And yeah, so a 1-car garage should address most of the parking issues there, because I agree. I live in East Nashville, so when you're talking about the street parking, my street is a lot worse than this one when it comes to the street parking. And sometimes, as developers, I buy a lot and the city tells me, hey, get rid of this driveway. We want street parking. We want to encourage alley parking, So sometimes, these things contradict each other. But in my opinion, I think, 2 homes here won't disturb the peace of the neighborhood. It'll actually bring more value to everything around it, all of the homes that are up and down the street.
Additional question is, I know you are working on the home design, and I believe some area do not allow like a front-facing garage. So if that's the case in this location, do you have a capability to have shared driveway and then place the garage, 1-car garage in the rear of the house?
I don't think there's room for a garage in the rear just because we'll have to have room for them to pull all the way behind the homes. I think currently there's 6 feet in between the homes. NDOT requires each driveway to be at least 25 feet away from each other. So if we tried to put it, the only way we could try to do that is if we put it on the right side of the property and we just had a long driveway that went all the way around the back. But again, NDOT requires that curb cuts are 25 feet away from each other. So I think that would be a major challenge there. But if we weren't able to do 1-car garages, then we could just put 2 parking pads.
Yeah, and that required those 2 houses use shared driveway.
Yes.
They're not allowed to drive car. So either way, you will have to have 1 driveway cut. So I think the question is the
So
location.
I'm talking about the neighbor
driveway.
next door. So 103. So I have to be 25 foot away from their driveway. So if I put it on the right side of my property, which is basically on the property line, I won't have that clearance. So that's why we elect to put it in the middle of the property to achieve that,
And also you are required to have 5-foot buffer because your property
Off of the
is
property
CS,
line itself,
and then
yeah.
next door is residential zoning, so you have to have landscape and fence to differentiate from a residential zoning to commercial zoning. So that would be the requirement.
So that's on the opposite side, but to my understanding, 103 is commercial zoning. So yeah, on the opposite side, yeah, which we plan on doing a privacy fence regardless.
Okay, any questions from the applicants? For the applicants?
Just one last question, because I couldn't see it on the survey. So right now you're showing a 30-foot setback, front setback for the homes. Is that in line with the two homes that are also zone CS that will be next to it?
Yeah, we won't be in front of those
You
homes,
won't
so
be in front.
we
You'll
used.
be in line with those?
Yeah, we used pretty much the average of those.
Okay.
So if you look at the entire street, the reason that we have that discrepancy once you go from 107 to 109 is because somewhere way back when, looks like that whole entire corner used to be one lot that faced Dickerson. And then they started splitting up that lot and putting single-family homes on it. And then, as you see, all these other lots are a lot longer. So it's a lot more room for those homes to sit a little further back.
So you'll be in line with those?
Those to the right. If you're looking at it from the street, those to the right will be in line. So we won't, even though the code allows us to do 15 foot, in my opinion, I do think that's a safety hazard. If our homes are too close to the street, you know, kind of that home turning out kind of makes it a little harder. So that's why we are also being mindful for our height. The whole front setback variance thing came from because if we were forced to follow the contextual setback, we would only have room for a 26-foot property lengthwise, which then we would have to build 3-story, which that's not ideal in this area. We don't want to put a ginormous tall home. We want to do a normal 2-story starter home and bring in a first-time home buyer on this street. So our plan is to offer something that's extremely affordable.
And this is a question really for Joey. Sorry, I'm putting you on the hot seat a lot today. And this is really for clarification for the opposition here, just so we're all clear. If the applicant was seeking to put one single-family house here, they still would be in front of us asking for one single-family house, because by right, without coming in front of us, they would, what's the minimum density they would have to put here?
3 units.
3 units?
Yes.
So, so in theory, they could not come in front of us and put 3 units on it and not have to go in front of the Board of Zoning Appeals, correct?
Yes.
Okay.
And the one thing council changed in this one, we hear of, complaints from neighbors about short-term rentals. This development cannot do short-term rentals in it as a part of this development. Whereas you've had those cases like on Dickerson before, those big high rises, and remember the council member asked you to put a condition to not allow short-term rentals. When they wrote this new ordinance, they specifically prohibited them on lots that are not on arterial streets or collector streets. So even though they're single-family homes, and they might even be individually owned, we're not going to issue STR permits on this lot. Because of that, because they're coming to you to get to 2 units by way of the adaptive residential section. And because they're using that section, they get the good and the bad. They get the ability to come here and ask, but they lose the ability to do short-term rental. Whereas if this were RS5, like the neighbor, you could, as long as the owner lived there, we'd issue a permit.
Right.
Or if it's a duplex, as long as they own both units, we'd issue a short-term rental permit.
Right.
So you won't have that here. And the setbacks, if we were zoned residentially, it'd be a little different. I would probably still apply the setback rationale to use the 2 on the right rather than the ones on the left, because those lots are so deep, it skews the average for these smaller units here. You couldn't even build on them based on the average of the houses to the west.
Right.
Because those lots are so much deeper. So I'd kind of look at it like 2 separate little block sections. I believe that the neighbor had a question I wanted to address because can't come back to approach y'all unless the hatched lines that's on the map is the urban design overlay, and that affects aesthetic appearance of new commercial and mixed-use construction along that Dickerson Pike corridor. It doesn't apply to these 2 lots, but as you see, it just kind of chops off
Yeah, it's in my backyard there, and
It spills over into your backyard a little bit. I would say more than likely, it's probably a map error. It probably should follow that line, and then everything should slide a little bit east, and follow those property lines.
Thank you, Joey. And I guess one more follow-up for you is, what we're in front of us is really just the down zone of this is in front of us. Would we be able to codify the setback at the same time? Or is that kind of out of our reach?
Council would have to apply a contextual setback but as I told you previously, this would be the last case to come before you for 1 and 2 family, so they don't have that option.
It's not that I distrust the applicant, but
No,
the ability to.
Well, I mean, you can certainly condition an approval upon this plan, or a 30-foot setback, or, he's testified that he's only doing 2 stories. He's entitled to do 3, but you could condition that it's just for 2 stories, not to exceed X height based on his own testimony. In a roundabout way, he had said it, but he sort of offered up conditions, my PC's down, offered up conditions to you, which you can incorporate it if you feel necessary.
Okay. Thank you, Joey.
Yes.
Any more questions for the applicant? Okay, we'll close the public hearing and discuss.
I mean, I think they've got a small lot in a weird spot, not meant to rhyme, with obviously a 10-foot sewer easement, and I think they're doing the best they can with it. They can't put 3 units on it, technically, without 3 units at 15 feet, without coming in front of us. So I think they're doing the best they can with the property and trying to stay within the context of the neighborhood. I know, some of the other houses sit a little bit further back and maybe are a little bit larger, but these are 2 single-family homes. I think I'd like to make sure that there's a contextual setback to the 2 houses. I'm not sure which direction it is, but to the right, the 2 ones with the smaller houses, whether that's 30 feet, 32, 29, whatever the contextual setback is. And I don't necessarily have any requirement for height on that front, but I think the setback's important just for safety and everything else. And then as far as stormwater goes, that the opposition brought up, I believe that there's, base restrictions that new homes have to follow, stormwater management with underground drainage to mitigate any shedding from one lot to the next. So that's my take on it.
Yeah, I would like to address one thing. It's same as previous case, because planning recommend disapproval because the policy called for high-rise, 12-story high. So with that, vision and what is proposed, I think what is proposed is more appropriate for that particular lot. Maybe larger, corridor study may call for that higher density and that extreme height. But in this particular lot with contextual and surrounding neighbor, I think what proposed is more in line with policy. So I'm in support of that. For that reason, I'm in support of this application. And as well, I'm support of the front setback, because it should be 30 feet instead of legally allowed 15 feet. And garage, if it's possible, would love to see not, parked on the street.
I think again, going back to the sewer easement, even if the particular area doesn't allow front-facing garages, I think that could be, not that they're here for that, but however we could layer that on as a condition. And just for clarification, I wouldn't do 30 feet. I would say whatever the contextual setback is of the 2 associated homes, because I don't know exactly what it would be.
Well, everybody's nodding, and I think they're probably in agreement. So if you want to make a motion with a setback proposal.
Sure, I'll make a motion to approve the applicant's request with the additional, I guess.
Condition.
Thank you. Additional condition that its setbacks are are in line with the average of the two properties to the right of the home if you're facing it from the street. I'm not sure which direction that is. East to the average of the two properties to the east, which is roughly 30 feet, but I think would have to be calculated.
Okay. You can't, I'm sorry, we've closed the public hearing, we're voting.
I think that's a good idea.
Okay. All right, well,
And that's it. I wouldn't make any other further conditions unless anybody else wants to add any.
that's fine with me, so I'll second
Is there a
it.
second? Yeah.
Yeah, so there's a motion, a second, any further discussion?
I think it's clear without saying, but follow the landscape buffer and, tree requirement that, specified in the condition.
Yes, for CS.
Yes.
Yes. To add the further, I mean, I guess this goes without saying, but you want me to, I would say also just to make sure that the applicant follows the associated buffers and tree fencing requirements in the CS district. And, I don't want to make this a condition, but just does the best of their ability to make sure that the stormwater is mitigated.
Okay, there's a motion, second. Any further discussion? All in favor? Okay, that passes for it.
Okay.
All right, last case.
Yes, sir. Is the applicant present on case 2024-252, Kenny Lou Allen, 615 9th Avenue North, seeing that everyone in the audience is leaving? Mr. Chairman, we're going to dismiss this case for lack of prosecution. I know the applicants were notified, so. All right, that will conclude our agenda for today. Again, just a reminder, we do have a meeting on the 19th, and I do expecting Ashanti to rejoin us back in January. So, all right, thanks.
All righty.
So can they build as high as they want to, or is there limitations on that?
There are limitations.
2 stories?
Yeah.
Okay, so that's in the,
Yeah, the height restrictions in the commercial district are
is there a number? That says they're building residential.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.